Vanderstock. General Prelogger.
Mr. Chief Justice, and may it please the Court, the Gun Control Act imposes straightforward but essential requirements. Firearm sellers and manufacturers must mark their products with serial numbers, maintain sales records, and conduct background checks. The industry has followed those conditions without difficulty for more than half a century, and those basic requirements are crucial to solving gun crimes and keeping guns out of the hands of minors, felons, and domestic abusers. But in recent years, companies like the respondents here have tried to circumvent those requirements. They've begun selling firearms as easy-to-assemble kits and frames and receivers that require minimal work to be made functional. They've advertised the products, in their words, as ridiculously easy to assemble and dummy-proof, and touted that you can go from opening the mail to have a fully functional gun in as little as 15 minutes. No serial number, background check, or records required. Those untraceable guns are attractive to people who can't lawfully purchase them or who plan to use them in crimes. As a result, our nation has seen an explosion in crimes committed with ghost guns. In the face of that public safety crisis, ATF promulgated this rule to underscore 2 points about the Gun Control Act's plain text. First, a weapon parts kit that can readily be converted to function as a gun with common tools, often in under an hour, is a covered firearm. Second, a product is a frame or receiver under the Act, even if the buyer must drill a few holes or remove a few superfluous pieces of plastic to make it functional. Both of those points are consistent with how ATF has interpreted and implemented the Act across 5 decades and 11 different presidential administrations. Respondents now seek a sea change in the Act scope. They claim that if a firearm isn't 100% functional, if it's missing just one hole that could be drilled in seconds and immediately assembled into a working gun, that product can be sold to anyone online with no background check, no records, and no serial number. That contradicts the Act's plain text, and it also contradicts common sense. This Court should make clear that the Act regulates these products as what they are: firearms and frames and receivers of firearms. I welcome the Court's questions.
Does this new regulation cover all of Chapter 44?
Yes, so I think that the understanding of a firearm reflected in the final rule does reflect the 922A13 definition.
Would it also apply under 924?
Yes, and so I think that that also incorporates, though, Justice Thomas, the mens rea requirements that are under 924, which I think guards against some of the concerns that respondents have raised in this case, that manufacturers could unintentionally be swept up by these restrictions. For example, 924A1D requires a showing of willfulness with respect to selling products without a serial number or without a license.
You make a lot of the fact that this has been regulated for a half a century, but it wasn't regulated in this way for a half century. What was the original reg, the previous reg?
The previous reg defined a frame or receiver with respect to particular components that were housed in that primary structure. But Justice Thomas, I agree that this rule reflects any fundamental change in approach, because under that prior reg, ATF consistently recognized that even when that frame or receiver, the primary structural component, wasn't yet fully finished or complete, still it would qualify as a firearm looking at the same factors that are listed in the rule. Things like, how much time is it going to take to make it functional? Do you need special equipment? Do you need to buy parts, and are they readily available? Do you need special skill? So all along, from 1968 on, the agency has consistently focused on this same issue of how quickly you can make that frame or receiver operational as part of a working gun. And the only change in the rule, and I want to openly acknowledge this as the rule does, is that ATF is now taking account of jigs or templates, which are a form of tool that quickly speed up the process of making a frame or receiver functional, because they show you exactly where you have to drill in that weapon, so there's no trial and error or guesswork. But as ATF explained in the final rule, that wasn't a change in statutory interpretation. It was just a recognition that jigs serve precisely the same function as something like indexing, stamping the frame or receiver to show you where you have to drill. So it goes directly to the question that the agency has asked all along, namely, how quickly, easily, and efficiently can this process be completed?
General, I'm looking at agency letters stretching back as far back as 1978. and each of them basically use the same language that the current regulation is using. The agency letter in 78 said it evaluated an item on whether it had reached a stage of manufacture such that it might be readily converted to functional condition, correct? That's what you're talking about?
Exactly right. And I think that that refutes Respondent's suggestion here that ATF had somehow been applying a different standard over the 50-year history of the Gun Control Act. Instead, ATF has always looked at whether the item has reached a critical stage of manufacture by reference to what work remains to be done to make it functional. So it's not like these are entirely separate and distinct contexts. As the 1978 classification letter you referenced makes clear, the only way to measure whether something has reached a critical stage of manufacture is to look at how close it is to the final product and what steps you need to take to turn that into a functional frame or receiver.
General, I want to know what our standard of review here is, because I can imagine a frame or receiver that is just a block of metal that's not readily convertible. I can also imagine some part kits that require such tremendous amount of work that it doesn't qualify as readily convertible. So if I can point to one item that wouldn't qualify, could be swept up potentially by the new regulation, is that enough to defeat a facial challenge? Is it enough? Or is that always an as-applied challenge?
That is definitely not enough to defeat a facial challenge. So there is no particular product before the court in this case. Respondents have chosen to sue in this facial pre-enforcement posture. And what that means is that the only question the court should be asking in this case is whether there is anything on the face of the rule that is contradicted by the statutory text. In other words, whether the standards that ATF set forth in the rule are themselves contradicted by the statute and therefore foreclosed by the statute. And they can't make that showing here. It's certainly true that they try to suggest, and your question touches on the idea that there might be particular marginal products out there that could test the bounds of whether something is readily convertible, but the court doesn't need to consider those kinds of products in this case because that can all be adjudicated on an as-applied basis going forward.
You use our statement in INS versus NCIR, which basically tracks what you're just saying. But in Reno versus Flores, we use a different standard and said that a respondent to prevail must establish that no set of circumstances exists under which the regulation would be valid. You didn't go that route.
That would be an even more stringent standard, and I think
agree.
a burden that respondents can't surmount. But we think even under the INS standard that we cite in our brief, it's very clear that there's nothing on the face of the Gun Control Act that
How
prohibits
about the
this
Washington
approach to
State
regulation.
Grange standard, which says even if there might be some applications that are intermissible, those possible applications cannot render the rule facially invalid so long as the rule has a, quote, plainly legitimate sweep?
Yes, and I think that that standard is equally satisfied as well here. You pointed to the hypothetical possibility of marginal cases where a product would take a lot of time to put together, but I want to emphasize the core of the conduct that this act regulates, which were the ghost gun kits and partially complete frames or receivers that were flooding the market leading up to promulgation of this rule. Those are issues or products where the readily convertible determination was not hard at all because the products were specifically designed and marketed to individuals who could put them together with no specialized skill and often in under an hour with common hand tools. And so I acknowledge the point that maybe there could be other hypothetical applications of the rule that could test the bounds with respect to certain factors. But I think that under any conceivable standard for adjudicating this facial challenge, respondents haven't come anywhere close to satisfying their burden to show that the statute squarely forecloses the standards in the rule.
What is the meaning of the term weapon in 921A3A? Can you give me a definition?
Sure. So that's an undefined term, and we think it therefore carries its plain dictionary definition as an instrument of offensive or defensive combat. But nothing in Congress's use of the term weapon suggests that it has to presently be functional as an instrument of combat in order to qualify. And in fact, I would say the rest of the statutory provision makes clear that the weapon might well have to undergo a conversion in order to operate as a gun. There's an express
It may have
reference.
to undergo a conversion, but before it's converted, it must be a weapon.
That's right. We certainly don't dispute that it has to be an instrument of combat designed and intended to be used in this way. And Congress made clear in the statutory history that the reason it used that term is because there are objects out there, toys and tools, that have a well-known non-weapon use, but that actually do expel projectiles through the action of an explosive. A cap gun is an example of this. It expels birdshot, and so therefore it would fit within the functional definition, but it's not a weapon because it's not an instrument of combat or intended to be used that way.
Is it the case that components that can easily be converted into something constitute that thing before they are converted as a matter of ordinary usage?
I think that as a matter of ordinary usage, we're not suggesting that any statutory reference to one thing includes separate and distinct things that can be readily converted. So shifting to our arguments under framer-receiver, subparagraph
No,
B.
I want to stick with the definition of weapon for just a second.
Oh, sure.
I'm going to show you. Here's a blank pad, and here's a pen. All right? Is this a grocery list?
I don't think that that's a grocery list, but the reason for that is because there are a lot of things you could use those products for to create something other than a grocery list.
All right,
And so it's not like they're...
If I show you, I put out on a counter some eggs, some chopped up ham, some chopped up pepper and onions, is that a Western omelet?
No, because again, those items have well-known other uses to become something other than an omelet. The key difference here is that these weapon parts kits are designed and intended to be used as instruments of combat, and they have no other conceivable use. And I think the further evidence comes from the fact that respondents themselves agreed that a disassembled gun qualifies as a weapon. So this is on page 37
Okay, so
of the
that's
Vanderstelt
helpful. So
brief.
your definition is a group of components that can readily be converted into something and have no other use. They must have no other use in order to constitute that thing.
In the
that
circumstance,
situation, they already constitute that thing.
I think that you can recognize that something is a weapon even if it's non-functional, if it is clear from objective evidence.
No, I think that certainly is true from the face of the statute, because it has to be, it's sufficient if it's capable of being converted into something that can expel a projectile. All right, thank you.
General Prelogger, I just want to follow up on Justice Alito's question about the omelet. Would your answer change if you ordered it from HelloFresh and you got a kit and it was like turkey chili, but all of the ingredients are in the kit?
Yes, and I think that that presses on the more apt analogy here, which is that we are not suggesting that scattered components that might have some entirely separate and distinct function could be aggregated and called a weapon in the absence of this kind of evidence that that is their intended purpose and function. But if you bought, from Trader Joe's some omelet-making kit that had all of the ingredients to make the omelet and maybe included whatever you would need to start the fire in order to cook the omelet and had all of that objective indication that that's what's being marketed and sold, we would recognize that for what it is. And it doesn't stretch plain English to say, I bought omelets at the store if you bought all of the ingredients that were intended and designed to make them, especially under statutory language that refers to something like breakfast foods or things that can be readily converted to make breakfast.
Go ahead. Can I ask you about the difference between the destructive device and machine gun definitions that also reference parts in a way that this definition does not? I've just been thinking about, in 1968, in the Gun Control Act, why Congress might have done that differently. And these ghost guns weren't around. These kits are a more recent problem, which doesn't mean that the plain language doesn't cover the unintended consequence. But in 1968, and I don't know enough about the gun industry to know if this is right, which is why I want your take on this. Wasn't it the case then, I think, that destructive devices like grenades or things that you tended to buy whole because they were so heavily regulated and even illegal to purchase that way as opposed to firearms? So they were generally purchased as components or things that were, able to be converted or made. Like, it would make sense to think about it in terms of parts. Am I thinking about that correctly based on the industry at the time?
Yes, you're exactly right about that relevant difference and how people were ordinarily constructing things like destructive devices that weren't sold in these types of kits. And I think the important thing to recognize, and what this question presses on, is that Congress can use a variety of verbal formulations to cover similar types of conduct. Each of these other definitions that respondents have pointed to that refer explicitly to parts were enacted at different times from the relevant definition of a firearm, and they address different issues in the way that your question touched on. But what respondents are doing is ignoring the language of the statute that Congress did use in 1968, and it expressly referred to things that can be readily converted to function to expel a projectile through the action of an explosive. It's hard for me to see how a weapon parts kit doesn't fit within that plain language, because quite literally, the kit is intended and designed to produce that functioning weapon in a very short amount of time by people who don't know anything about guns and can do it with relatively little skill.
General, I understand your argument under A with respect to things that could be readily converted, but there's also the argument under B, frame or receiver, which doesn't include that kind of language that might bring in artifact nouns more obviously. What's your thought about that?
So I do think there's language in B that gets us there, and it's the fact that Congress referred to frame or receiver but didn't expressly define that term. It's true that in subparagraph A, Congress used the exact language readily converted, but that's because that's Congress's definition of the term, and if it had defined it solely in terms of the functionality of a gun, if it had just said something that functions as a gun, that would be limited to operational weapons. So Congress had a really good reason to use the language there.
Gotcha. I follow all of
Yep.
that.
So then
now moving on to B,
So
though.
moving on to B, Congress didn't define the term, which means it carries its plain and ordinary meaning. And we think that the ordinary meaning of a noun like frame or receiver includes objects that are nearly complete but are missing just a few holes that need to be drilled.
Now, we can't possibly think that every noun that Congress uses everywhere in the U.S. Code is used as an artifact noun that carries with it things like Justice Alito's pen and pencil as a grocery list, right? So there's got to be a line that makes this, on your theory of the case, why we should read that into B here, but not everywhere in the U.S. Code. What are your thoughts?
Right. So I want to be very clear that we think that this is a matter of ordinary meaning, that you don't need it to be 100% complete. And that I think that runs across the board. If I mentioned a bicycle, but it was missing pedals, as we explain in our brief, you would still recognize that for what it is as a bicycle. That's the first order question. But then the second question arises that you touched on.
If I'm not inclined to think that every noun is used in that way in the U.S. Code, I mean, that would be a very dramatic argument, right? Lenity, notice, fair notice to people that every piece of paper and pen is a grocery list. You're on notice of that. But is there something particular to this statute that you think would a more narrow approach?
Yes, we think the context and purpose of the statute strongly support understanding the term in this way. And the reason for that is because throughout the federal firearms laws, whenever Congress has itself expressly provided a definition, it has included not only the fully complete and functional item, but things that are the item and can readily be made to function that way. So I think that's Congress's own indication in this statute that it's trying to ensure coverage not only of things that have the functionality of a frame or receiver at the moment they're sold, but frames or receivers that can be readily converted to function with minimal steps.
And also address your friends on the other side, I'm sure going to make something of this, that as recently as 2021 in a brief filed in the Southern District of New York, the government represented that an unfinished frame or receiver does not meet the statutory definition of firearm.
Sure, so let me take those in turn. With respect to text, what we have, Justice Gorsuch, is the term frame or receiver that's not defined, and the court has many times recognized it needs to interpret text and context. I think the anti-circumvention principle carries a lot of weight here, because if respondents are right and just one undrilled hole is enough, then basically that coverage for frame and receivers does no work.
Does it help that C and D deal with mufflers, silencers, and any other destructive devices that don't have conventional frames and receivers? Does that help you?
I think that that just goes to show that Congress was trying to broadly cover the scope of products that can qualify as firearms, and it certainly refutes respondents' suggestion here that every covered object under the statutory definition needs to have a traditional frame or receiver.
That's what I'm wondering, whether looking at C and D and A, which, as you say, carries some broad language about not just complete items, might be a textual way to narrow and focus on B without saying every artifact noun in the U.S. Code carries this feature.
Yes, I think you certainly could adopt that interpretation, and that contextual surrounding evidence strongly supports our arguments in this case. I don't want to lose track of your question about the brief district court filing in the Syracuse case. I want to be really clear that I think respondents are fundamentally misreading that brief. They suggest that the brief stood for the principle that ATF was arguing that a frame or receiver has to be fully functional functional to qualify. But if you actually look at that brief, that's not what it says. It walks through the statutory and regulatory history here and makes clear that repeatedly over 5 decades, ATF has always looked at whether a partially complete frame or receiver can be brought to functional condition quickly, easily, and efficiently. So there is no dramatic break in the way that ATF has regulated throughout the entirety of the statute's history.
No, I'll look at that again. And then last question from me, and I'm sorry to take up so much time. In the regulation, it indicates that a frame or receiver, and I'm stuck on this B point, which has been cut into pieces, is still a firearm.
So this has...
But one that's been shredded is not. Now, I'm not sure what the difference between cut into pieces and shredding is, but perhaps you can enlighten me and help me there.
So this refers to when you already have a fully complete and functional firearm, what steps you would need to undertake to formally destroy that firearm and exempt it from regulation. Those are not provisions.
So it's no longer readily convertible, right? And
so once you actually have already brought something within the regulatory scope of the statute, the statute itself and the agency's regulations require that it be destroyed, which is a specialized term in the firearms industry. I can tell you as a factual matter that the most common way that you destroy a firearm is to torch cut it with 3 specified cuts that ATF has provided guidance about.
This is, I'm sorry to interrupt, but this is actually about frames and receivers that I'm talking about, and it's 478.12 C and E.
Yes.
Okay? And it talks about partially complete, disassembled, or non-functional frame or receiver. That's what we're talking about, not the firearm. And again, maybe there's a line a through line, but I couldn't find one between shredding and cutting into pieces. I would have thought that's pretty much the same thing.
So that comes, as you mentioned, from 478.12E, which I should note respondents haven't challenged in this case. It tees up a distinct statutory issue about what it takes to destroy a frame or receiver or a regulated object once you already have a firearm. They aren't challenging that here, and the only thing that is before the court is the definition in B, recognizing that you don't need a fully functional firearm in the first place.
No, but it illuminates what is a sufficiently complete frame or receiver if a complete frame or receiver is not a firearm. And the only way I can be sure that I don't have a fully complete or nearly complete or convertibly complete frame or receiver, and therefore a firearm, is to shred it but not cut it into pieces.
No, let me try to clarify that, because that's not accurate at all. As the regulation itself makes clear, you don't even get to the question of asking whether it's readily converted into functional shape unless you have the clearly identifiable unfinished component part. So you have something that is already well along the way to being a frame or receiver, and that's when you would conduct the readily converted inquiry. And there is nothing in the rule or in the agency's past practice to suggest that anything that isn't shredded or cut up or absolutely destroyed is going to be considered a frame or receiver. That would be entirely inconsistent with how the agency has implemented the statute all along.
Thank you.
Under the rule, what percentage of the parts of a firearm kit must be included in order for it to be a firearm kit?
So these kits always come with a frame or receiver, and I think that that's going to be a necessary part. That's usually the part that needs just a couple of holes drilled or pieces of plastic removed. And then the weapon parts kits generally come with the additional components that will allow you to form a fully functioning gun. If you're asking whether it would still qualify as a regulated weapon that can be readily converted if it were missing other parts, I think that's a matter of degree, and it presses on what it means to readily convert. It might be fact specific, so if the part you're missing is something that is super specialized and would be hard to track down or is going to cost you $1 million, that might not be readily converted. But if you have something that's missing a single pin that you might even have lying around the house, it probably will be. Again, in this facial challenge, I don't think it's necessary for the court to consider all of the possible permutations of how this could play out with respect to different types of products. The thing that you need to be asking is, did the agency reasonably define the term readily? And it did, because it gave it its ordinary definition of a process that's quick, easy, and efficient. And then did the agency identify relevant factors? And I think it did with respect to things like time, expertise, scope of work, and as your question touched on, what parts you would need to actually make it functional.
General, we have a clue from the statute's use of a starter gun as an example of something that's readily convertible. As I understand it, to make a starter gun operable, you either have to replace the bore, so you need a new bore part to do that, or you have to drill out the existing bore on the starter gun and get a pin to make it operable, correct?
That's right. So the most commonly publicized example that I think was top of mind for Congress, and it's one that's cited in the statutory history here, was the example of a gang member who bought these starter guns in bulk, and then you're exactly right, had to drill out the plugged barrel or else cut it off and rethread it and put in a new barrel. And often you also have to enlarge the barrel so that it can chamber conventional ammunition if it isn't already able to accept bullets.
So we know that some incomplete items qualify under the statute's definition.
Yes, and I think that also shows, as the statutory text makes clear, that things that aren't presently functioning as guns but can be readily converted to function are covered under subparagraph A. That was exactly what Congress was trying to accomplish, to ensure that these things that are going to be used as instruments of combat and that can be completed to functional condition with minimal work would come within the scope of the federal firearms laws.
Thank you, Counsel. Justice Thomas and Justice Alito.
Were weapons parts kits common in 1968?
So there have only been a couple of examples over the years that I'm aware of reflected in the case law. We cite the Stewart case and the Witt case. One of those was kind of an Uzi making kit. Another one involved someone who was making it possible through kit form to construct a machine gun. It wasn't particularly common then, and I can tell you the reason why. The big development and the technological development that led to the explosion of ghost guns was using polymer, a form of plastic, to make this.
Are there gun kits available now that do not consist of polymer parts, but instead consist of parts taken from disassembled firearms that have been altered in a way to make them non-functional without some modification?
I'm not aware of any commercial product right now that fits that description.
On what it means to be readily convertible, I don't know whether it's possible to do something, that's the statutory term, I don't know whether it's possible to do something more precise than what ATF has done, but it would be interesting, if it would be helpful if you could perhaps explain a little bit more what that means. So what level of expertise is taken into account? What collection of tools is taken into account? Can you provide any sort of a time limit? How long must it take? Some of us who are not and don't have a lot of mechanical ability have spent hours and hours and hours trying to assemble things that we've purchased.
I'm with you on that one, Justice Alito. As someone who struggles with IKEA furniture, let me do my best to try to be responsive to that question. And I think the thing to point to is the case law on this point, because ATF wasn't just coming up with these factors out of nowhere. Instead, because this is the term that Congress used in the statute, we have 50 years of judicial precedent further fleshing out the contours of when something can be readily converted. So as a general matter, what the courts, and therefore what the agency has said, is that it is readily converted if if a novice in a fairly quick amount of time can easily and efficiently convert their weapon to function. You asked about outside bounds like time limits. I can tell you that in the case law, the longest period of time that was ever deemed still readily convertible was 8 hours, and the agency has not considered any product greater than 8 hours to be readily convertible. So if that issue were squarely presented, a court might hold that something like a day's work or 8 hours sets an outer bound. With respect to things like skill or parts availability, obviously that's going to be fact and context specific. And I think the important thing to recognize is that these are principles that were themselves drawn from case law, and the agency, I think, can't be expected to do better than courts themselves have done in trying to flesh out the qualitative standard that Congress chose to use here.
Thank you.
Justice Sotomayor. Justice Kagan.
On parts kits first, in addition to the parts kit that's analogous to an IKEA table kit, Judge O'Connor below was concerned that that language would include sort of any aggregation of gun parts. So let's say, a gunsmith just wanted to replenish inventory and got a big box of gun parts generally from a gun manufacturer. Would that count under the ATF regulation?
No, the lower court fundamentally misunderstood how this final rule operates. In the first place, it doesn't regulate something like a gunsmith at home who's buying individual parts and seeking to aggregate them. This is a regulation that only governs commercial manufacturers and sellers of firearms who are themselves constructing the weapons and the kits and putting them on the market. So these are just conditions on commercial sale. And then with respect to what the rule would cover, it's clear from the readily convertible analysis that you need to have a process that's fairly quick, easy, and efficient. And so it wouldn't sweep in things that have a lot of other uses and that would require a lot of skill and expertise or time to track down the missing parts to put together. And I want to emphasize again, it's not like ATF was coming up with this rule without real-world experience about the kinds of products that these fringe manufacturers were putting on the market. These were kits that you could put together in under an hour. They had all of the relevant components. You would just need to do a little bit of finishing work. I actually had the experience of putting one of these kits together, and it's just like what the record shows. There are usually only a couple of steps. The first thing that most of the kits require is drilling the holes. Usually it's 6 holes, and you do it with the jig. So you have the product there in the tool, and it removes all of the trial and error or guesswork. You know exactly where to drill in seconds. The second step is to remove the extra plastic blocking tabs. That, again, doesn't require much work at all because you clip them off with a pair of pliers or a box cutter. You can file it down with a jig as a template using a metal nail file or using a Dremel rotary tool that a lot of people, especially dog owners, own because it's helpful for trimming your dog's nails. At that point, you have a fully functional frame or receiver, and you can quickly assemble it into a gun in no time at all. That's how the products were marketed. That's how they were sold.
And turning to the frames or receivers, you made a point of saying that this follows in a long line of regulation. But there were changes, right, that the new regulation is intended to capture items sold with jigs and templates. Is there anything else that the new regulation was intended to capture that was not captured under the old? And why did ATF make that change?
No, that is the only change. ATF made that change and openly acknowledged and justified its decision because it recognized that when you have a jig, which is this tool, as I mentioned, that removes all of the trial and error and really does make it dummy-proof, as the manufacturers have claimed, it goes directly to the question the agency has asked all along, which is how quickly, easily, and efficiently can this thing be made to function? So it's no different in kind from indexing on the frame or receiver. Indexing is something that ATF has looked at from 1968 on. It's always recognized that if you actually put a dimple in the frame or the body of the structural component, that's going to speed up the process, and jigs work exactly the same way.
And let me ask you a broader question. If we step back a little bit, sometimes this court looks at regulations and it says, you know, there's an old statute, and the old statute doesn't contemplate a new problem. And a new problem comes up, and Congress can't get its act together and deal with the old problem, and so the agency takes old statutory language that doesn't really fit the problem, but, you know, is vague enough or general enough or broad enough, you know, so that it can be kind of made to deal with the new problem. And this court has sometimes said, well, that's not right. The new statute had nothing to do with, the old statute had nothing to do with this new problem, and this is kind of, you know, the agency just taking over what is really Congress's business. Is that a storyline that the respondents here can tell about this regulation?
No, I don't think there is any tenable way to characterize this regulation as an attempt to change the meaning of the statute to confront a new problem. First of all, this is an age-old problem. Congress, I think, rightly recognized that manufacturers might seek to evade these central requirements. That's why anytime it's expressly defined a term, like in subparagraph A, it's included concepts of whether an item can be readily made to function. We think the weapon parts kits are precisely described by that subparagraph A description. I acknowledge in subparagraph B, it's not a defined term, frame or receiver, but there again, we think that Congress was simply tracking ordinary meaning, which recognizes that if you have that principal structural component of a handgun, that can be recognized as a frame or receiver, even if it's missing the single final hole that you need to drill in that. So I think it would be wrong to suggest that the statutory language, just on its own terms, doesn't cover this situation. And then on top of that, we have context and purpose here. On respondents' theory of this statute, it would be incredibly easy for any gun manufacturer to avoid the regulation and the essential requirements of serializing, background checks, and record keeping just by leaving one little part of the weapon or the frame or receiver unfinished. Plainly, that's not what Congress was intending, and I think it brings this case squarely within cases like Abramski, where, as you know, Justice Kagan, the court recognized that if you have an interpretation of the Gun Control Act that is going to allow that entire circumvention and essentially nullify the Act's requirements, the statute shouldn't properly be interpreted that way.
That was a close case. You maybe want this to be a stronger case than Abramski.
It is a stronger case, and the circumvention here is even more profound because it wouldn't just be in the sales transactions with the straw purchaser. It would effectively be all weapons going forward would not need to be serialized or sold with background checks and record keeping.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
Your statutory interpretation has force, but I had some concern at the stay stage, and I have some concern now about mens rea. And this is an agency regulation that broadens a criminal statute beyond what it had been before. So what about the seller, for example, who is truly not aware that they are violating the law and gets criminally charged? What assurances can you give about mens rea, about instructions to the jury that the government would seek and the like?
So let me begin with the statutory mens rea standard that I think fully addresses this concern. This is in 18 U.S.C. 924A1D, and it requires willfulness. So that means that if a manufacturer isn't putting a serial number on it because the manufacturer believes in good faith that this isn't a regulated product and the manufacturer doesn't know that it's violating the law, it will not be criminally chargeable because the government won't be able to prove that mens rea of willfulness. So I think that's an important check against criminal prosecutions that might be unwarranted. The second thing I would point to is—
Does this willfully apply to all potential prosecutions that we're talking about in this case?
It applies if there's no serial number on the weapon, and it applies if the weapon is being sold without a license. I believe that with respect to not conducting a background check, that's under a different provision that requires knowledge. But of course, the kind of entry point for the weapon is whether or not it has a serial number, and that happens at the point of manufacture. I also want to emphasize that to the extent that there is really—
So how would that work on the background check? I just want to make sure I'm not missing something there.
Yeah, so I think on the background check, if you have a seller out there who wants guidance about whether, with respect to particular type of products, it's necessary to do that background check, the person can seek a classification from ATF. The manufacturers would be the ones to do this, and this is a way to get a pre-enforcement dispositive ruling from ATF as to whether that's deemed a regulated firearm. And in that circumstance, if you don't like the answer that ATF gives, you have a right to judicial review that will be conducted under a de novo standard about whether this is a covered product.
But if you haven't done that, so you haven't done that, and you truly,
Right.
take the hypothetical, you truly believe you're not violating the law, could you be charged under that provision?
As a theoretical possibility, I think only with respect to background checks, it's possible you could. I'm not aware of any prosecutions that look like this, and the whole point
Is
of
that
this
something the government would do?
I don't think that the government would be likely to charge someone in that kind of situation. And it doesn't look anything like what was happening, where the manufacturers were themselves the sellers, putting these products on the market with explicit knowledge that it was being put into the hands of teenagers, felons, and so forth.
That's helpful. Anything else you wanted to finish up with on that?
So I guess the only other thing I would say is that we think that there is a lot of protection for manufacturers who are seeking to comply with the law in good faith. ATF is not trying to hide the ball here. The point of the agency is not a game of gotcha to try to criminally prosecute people. There was a very serious public safety threat posed by the explosion and the use of these ghost guns in crimes. And so the whole point of this regulation is simply to put the regulated industry on notice of how the statute applies in that discrete context and how it's always applied since the statute was enacted.
And on that point, because you had a lot of classification letters that were out there, this was to collect everything and put everyone, as you say, on notice, adding a couple things, as you pointed out earlier, correct?
Right. And so I don't think that this is any vast expansion of the statute. We just think this is ATF's longstanding interpretation with
Some
the addition,
expansion.
only with the addition of looking at jigs. But to be clear, that doesn't change the meaning of the statute. It just changes the factors that are relevant under the statute when you're conducting a readily analysis.
Okay, that's helpful. Thank you.
Justice Barrett?
A question about AR-15s. So Judge Oldham expressed concern that because AR-15 receivers can be readily converted into machine gun receivers, that this regulation on its face turns everyone who lawfully owns an AR-15 into a criminal.
That is wrong. So I want to be really clear about our interpretation of the statute. We are not suggesting that a statutory reference to one thing includes all other separate and distinct things that might be readily converted into the thing that's listed in the statute itself. So the example we give in our reply brief is that a pair of pants is not regulated as a pair of shorts if you have a statute referring to shorts, even though the pants could be readily converted into shorts. That's because pants are a distinct object in their own right, and they have a separate identity. And the rule itself incorporates this principle by requiring that the regulated object, before you even get to a readily analysis, has to be clearly identifiable as the unfinished component part of the regulated weapon. So what that means is you would have to say, this thing is a clearly unfinished component part of a machine gun, a weapon that's designed to fire automatically more than one shot with a single function of the trigger. But you couldn't say that about an AR-15. That is obviously something that's designed and intended to be used for semi-automatic fire, and the fact that you might be able to undertake certain drilling and machining operations to convert it into a machine gun doesn't mean that while it has this separate identity and is standing alone, it would be regulated as a machine gun. The agency has never held otherwise. This, again, is the same interpretation that the agency has had all along, and it has never suggested that AR-15 standing alone are regulated machine guns.
Justice Jackson?
So Justice Kagan talked about the problem of the agency potentially taking over what is Congress's business. And I guess I'm worried about the different concern, which is about the court taking over what Congress may have intended for the agency to do in this situation. And so all of my questions, the reason why I didn't really engage in the other part of this is because all of my questions really, for you, stem from that concern. You've phrased the question presented in this case as whether certain items, weapons, parts, and kits, or partially complete and disassembled frames or receivers qualify as firearms within the meaning of the statute. And I guess I'm concerned about this framing because it doesn't seem to account, in my view, for the actual claim that the challengers have made here, which is that the agency has exceeded its statutory authority. And so I'm trying to figure out how we're supposed to address what I think is a distinct question about the scope of the agency's authority vis-a-vis the court to fill out the category of what is a firearm. I mean, are we to conclude that an agency exceeds its statutory authority whenever it fails to choose what we think is the best meaning of a statutory term? Is that how the scope of the agency's authority to promulgate a rule is supposed to be determined? We just compare what the agency believes qualifies as a firearm with what we think qualifies as a firearm, and if the agency has something in its definition that we wouldn't have put there, we say the agency has exceeded its authority. I think those seem not right to me as the way of figuring out the question of exceeding the authority. And I think it can't be assumed that the agency exceeds its authority whenever it interprets a statutory term differently than we would, such that all we have to do as a part of this claim here today is just decide what we think a firearm is. Can you react to that?
Sure. So I think, as in any statutory interpretation case, the task of this court is to determine what Congress intended and what it meant. And we think that we have clearly the best interpretation of the language that Congress used, but the court has said time and again that you don't just look at text, you interpret that text in context.
Right,
and
but
you can take account.
Can I take you on a little bit of a, let me just drill down a little bit, right? The term we are interpreting, I thought, was a category. Congress has said firearms, right, and frames and receivers, which it defines, the firearms part of it, have to be treated in a certain way. And I think in order to implement this statute, the agency has to look at real-world circumstances and determine what particular items fit into that category. I understood the delegation of this entire thing to an agency to be that task. That's what the agency's supposed to be doing. We look at firearm, we look at the definition of the firearm, says the agency, and we look at things in the world and we say X, Y, Z, those are in that category. My question is, when the challenge is X shouldn't have been in that category, does it exceed the agency's authority if the court thinks, yeah, X shouldn't have been in that category? Just, I mean, the agency still has the authority, I think. And in Loper seemed to recognize that Congress may have given the agency the authority to make certain calls. Right?
So I think in responding to this question, it's really
Yes.
helpful to distinguish between the facial challenge here and some of these as-applied applications of the agency's determination of what fits within the definition.
Okay.
I do think that if the court concluded that Congress, in drafting this statute, had, for example, categorically precluded looking at time in deciding whether something's readily convertible, then the agency would be exceeding its authority because, of course, if Congress has said in the statute, you can't think about time,
Right.
then the agency can't choose to do so.
Right.
We are miles away from that kind of situation here because all of the factors the agency listed on their face are consistent with the plain meaning of what it is to readily
So what you would
convert.
have us do is not come up with our list of what items we think should be in the firearm category. Like we have to think about exactly each thing. In this facial challenge, I think you're saying we need to do something more like, did the agency take into account the relevant factors for making the determination of what goes in this category?
That's right, because you don't have any particular products in front of you to examine in light of whether they would fit the definition or not. The only relevant question in this case is the facial question of, does this regulation conflict with anything in the Gun Control Act? And our answer is no. We think that this follows from the plain text of the Gun Control Act and is consistent with judicial precedent interpreting that plain text. With respect to any follow-on questions about particular products, that could all be assessed as applied in light of their specific facts to make a determination about how the factors might cash out in an individual case. But for the frontline question of the agency's authority here, we think everything in the final rule is consistent with the statute Congress wrote.
Thank you.
Thank you, counsel. Mr. Patterson?
Mr. Chief Justice, and may it please the court, this case turns on decisions made by Congress in the Gun Control Act of 1968. First, Congress altered the common understanding of firearm to include other weapons that may readily be converted to firearms. Second, in a departure from prior federal law, Congress decided to regulate only a single part of a firearm, the frame or receiver, and Congress did not alter the common understanding of a frame or receiver. ATF has now exceeded its authority by operating outside of the bounds set by Congress. One, ATF has expanded the definition of frame or receiver to include items that may readily be converted to a frame or receiver. And two, ATF has expanded the definition of firearm to include collections of parts that are not weapons and that do not include a frame or receiver. Some concern has been raised about circumvention. But of course, complying with the statute is not circumventing it. And as this court said in Abramski, which has already been referenced, Congress in the Gun Control Act did not seek to pursue its purposes of controlling access to firearms to the nth degree. And notably, Congress did not regulate the secondary market for firearms. And that secondary market is a much bigger source of firearms for criminals than privately made firearms. There also has been questions raised about the agency's prior practice. There definitely has been a sea change by the agency here. The agency projected that its rule would put 42 out of 43 unlicensed manufacturers out of business. And what the agency said in the Syracuse litigation was they said an unfinished frame or receiver does not meet the statutory definition of firearm simply because it can be designed to or can readily be converted into a frame or receiver. That's the exact standard they've now adopted. Instead, what they looked at was whether critical machining operations had taken place. And to be clear, we have no quarrel with that prior practice. We have raised as alternatives, one, something has to be completely machined, or two, the critical machining operation test. And the latter we submit is more consistent with the statutory language and solves the machine gun problem. Because if you say in the machine gun provision, a frame or receiver is also regulated, and if one hole is all that separates a semi-automatic receiver from a machine gun receiver, it's hard to see how the readily standard would not also be applied there. I welcome the court's questions.
Judge Oldham makes much of the 80% rule that was
Yes.
in stage of manufacture versus the what a receiver or an item is capable or can readily become. And we've had much discussion here about readily this morning. Is that analysis or that approach, does it make a difference as to your argument, whether it is the 80% rule or the current readily become rule?
Yes, I think it does for at least three reasons. One, we submit it can't be readily because when Congress wanted it to be readily, it put it in the statute in multiple circumstances. Two, it has a different practical impact. For example, in the machine gun frame example. So if the standard is readily and the government gives as kind of the paradigmatic example of readily drilling one hole, well, if all you have to do is drill one hole into a receiver to make it a machine gun receiver, it's hard to see how that is not a machine gun receiver. And three, the Congress said the frame or receiver. What Congress did not include in this statute was parts that may be used to convert an item into a frame or
I'm a bit more interested in how the 80% rule operated. We've heard
Yes.
much about the readily this
Yes.
morning, and whether or not that change actually took place and whether it really matters.
Yes, it does really matter. And just the 80% rule is kind of a colloquialism used in the industry. What the governing standard was called the critical machining operations test. And what the agency would do, based on what the definition of a frame or receiver is, the part that holds the essential firing and sealing components of a firearm, would say we're going to look at that part of the firearm and see if critical machining operations have taken place. And then as a cross-check, there sometimes would be temporal considerations. This is what the agency said in the Syracuse litigation. Temporal considerations were tied to the degree of machining. It was kind of like a lodestar cross-check in a fees case. So they would look at those temporal considerations. But where the difference would be made, and we can see this very clearly in the regulation of AR-15 lowers, and that is the same piece of metal can be considered a frame or receiver depending on what is sold with it. Under the old standard, you would look at the item itself, and that's what Congress did in the Act. They said, look at the item itself. It did not say, look at other things that may be used to convert that item into a frame or receiver, and that's what the agency is now doing, for example, with looking at the jigs, because really what is being done is that jig is being regulated, because the same piece of metal can either be a frame or receiver
But I
depending
thought
on what
readily convertible was in the statute.
Readily convertible is in the statute under Part A.
Okay.
It is not in the statute under Part B. So then you cannot, it would be very odd to say that, well, we're going to say readily convertible is a implicit in
For a
every
frame or
term.
receiver, but does the 80% rule apply then to Part A? I'm just trying to understand your answer to Justice Thomas with respect to the 80% rule.
Yes, and again, understanding that we're using 80% rule as a
Yes,
stand-in for
yes.
critical machining operations. No, that applies to Part B. That is what the agency would look at to determine whether something had become a frame or receiver. And if you're...
Counsel, doesn't
Yes.
that give your game away? Once you admit that you need to figure out when something has become a finished product, you have to have a standard to decide that. And you're saying the standard has to be something along that goes to manufacturing. The SG is saying, yes, that's just a silent way of saying, has the manufacturing gone far enough to make this essentially a frame or receiver? Can it be converted to be fully functional? That's what they're saying, that the two are doing exactly the same thing. You prefer one because you want to sell frames without a serial number or sell frames that you have to drill a hole in and say, that's not regulated. They're saying a hole is really not a critical component of the frame. Everything else is.
Well,
So I'm having difficulty understanding, once you admit that some sort of test is necessary, why this particular test exceeds their statutory authority.
yes, and so...
Since it's only a different way of getting to the same thing. Do I
Understood.
have enough of a frame or receiver to call it a frame and receiver?
Understood. And to be clear, we've provided the court two alternatives. One is that all of the machining operations have taken place. So if you were to say this was a sculptor, all the chiseling has been done, everything's been done, that this can now function as a frame or receiver. Our alternative.
You don't disagree that taking a tab off a frame, is that a completed frame?
I don't think taking a tab off, if you could do it with your finger, that's not
All right.
like actually removing material.
So if you have to drill a hole to attach it to something, that's not a completed frame.
Well, this is where the difference between the two alternatives that we have given the court comes in. Under the first alternative, drilling a single hole would be what would make it cross the line. And the government admits that sometimes drilling a single hole can be the difference between a semi-automatic receiver and a machine gun receiver. And a machine gun receiver is much more heavily regulated than a semi-automatic receiver. So the notion that just one hole separating something from another item is somehow absurd is clearly not the case. But the alternative we've given you is the critical machining operations test, and that is different from the government's new test because A, it's not conflicting with the statute by taking language from another part of the statute that's not there and putting it there, and where the government represented in the Syracuse litigation in 2021, we can't do that.
Let me
Yes.
come at it. Oh, I'm sorry,
Yeah.
Chief, please.
I would just, what is the purpose of selling a receiver without the holes drilled in it?
Well, some individuals, just like some individuals enjoy like working on their car every weekend, some individuals want to construct their own firearms. So the purpose of selling it is to allow,
I'm sorry, go ahead.
is to assist and provide individuals with material with which they can do that.
Well, I mean, drilling a hole or two, I would think doesn't give the same sort of reward that you get from working on your car on the weekends.
Well, I would encourage the court to read the Vasquez brief. This is not a easy thing necessarily to do, and particularly the Press Democrat article cited there where the reporter engaged to show how easy this was, and in fact show that he couldn't actually do it. He had to engage friends to help him complete this that were expert in the firearms. And even once you have a complete frame, it's not a trivial matter to put that together. There are small parts that have to be put in precise locations. And that reporter, that he couldn't put it together from the completed frame. So it's not clear that it is clearly not a trivial proposition for someone to do this.
Well, I don't know the skills of the particular reporter, but my understanding is that it's not terribly difficult for someone to do this. And it's certainly not terribly difficult to take the plastic piece out. Is that part of the gunsmithing?
Well, the plastic, the parts that are blocking the rails in the product that's been highlighted, that has to be taken out. It's recommended that you put it on a drill press vise and use a drill press with a specialized bit to take that away. And Polymerate explicitly recommends against using a Dremel. They say that could damage the product. And I know we don't have any particular product at issue here, but the point is that what Congress said is that we want to regulate the frame or receiver itself, and there's got to be some point. There's going to be a line.
I'm
Yes.
suggesting that if someone who goes through the process of drilling the one or two holes
Right.
and taking the plastic out, he really wouldn't think that he has built that gun, would he?
You know, I don't know what that person would think, but I think he would. It's not a simple proposition. Even the individuals that the government cited that took 21 minutes to put something together, it wasn't counting the time for the person to acquire the tools, learn how to use the tools. This person was a mechanic, so they knew how to do these things. Or the time to learn how to machine the object. That person spent 2 hours watching instructional materials before starting to put that item together. And even after that 21 minutes, the person had done it incorrectly, and it needed to be
Counsel,
repaired.
I'd like to circle back
Yes.
to Justice Sotomayor's question on B.
Yes.
I take that one position might be it has to be a complete frame or receiver
Yes.
because there's no indication of readily converted the way there is in A.
Right.
All right. I got that argument. But I think you've suggested that no, we accept that there are incomplete frames or receivers that count. This is indeed an artifact noun. And if that's true, well, first of all, is that true?
Well,
You
we've given,
concede that.
our primary argument is no, it's got to be complete, but we've given an alternative argument.
Okay.
That, okay, it could be an artifact noun, but if it is, the test should be critical machining and not readily converted.
Let me press on the first argument. Why wouldn't this be an artifact noun in this statute, given A, which does suggest incomplete things, can count, C, mufflers and silencers, D's, other destructive devices, which don't have a traditional receiver. I think the examples we've been given are umbrella guns and pen guns and things like that. Why wouldn't that be an indication that here, if not throughout the U.S. Code, Congress was using an artifact noun?
I would think the inference would be precisely the opposite, because Congress put that language specifically into those neighboring statutes, words like converted or words like collections of parts. So it would be odd to say that in this particular place where Congress has taken a special care to use that sort of language, when Congress wanted that language to be applied, to say, well, we're just going to infer that it also applies here, where Congress did not put that language. And I think it could, again, as I've said, it could wreak havoc with the firearm laws, because there are a lot of things that can be readily converted. A traditional rifle can be converted to a short-barreled rifle in minutes with a hacksaw or by swapping in a shorter barrel. So if this concept, readily converted, Congress only put it into specific places. And we can see in the machine gun provision, Congress said readily restored instead of readily converted. So we need to be very precise here. And in terms of why we would pick critical machining operations instead of readily converted, if we're looking for evidence of meaning, if we're not going to say it has to be completed, well, one evidence of meaning was what did ATF in the industry working together over a period of years arrive at? And what they arrived at was this critical machining test, because it does not pose these same problems as readily converted would, potentially with other provisions of the code, and it also is more consistent with the statute by not importing readily into a place where Congress chose not to put it.
Thank you.
Doesn't appear in the statute. It seems a little made up, right? The critical machining test. I mean, your other test, I think, has the problem of pulling a tab off the front and saying, okay, now it's a frame or receiver, but it wasn't before you pulled the tape. But the critical machining doesn't really come from the statute. It's just sort of a way of allowing for de minimis exception, right?
Well, I wouldn't say that, Your Honor. And first, we wouldn't, even under our primary test, I think it's, if it's machined, so, if you think of the sculptor, when everything's been sculpted, if something is put on to protect it or something and it just has to be pulled off, I wouldn't call that machining. So I think it's once all the holes have been drilled, all the material has been removed that requires tools to remove. That would be our primary test. But then under the secondary test, so that it would come from the language of frame or receiver. And I think you would say, okay, this is an artifact noun, but then what does that artifact noun mean? We have to still determine at what point something is a frame or receiver. And we think the evidence of meaning of the agency and the others in the industry who are very keenly interested in this question, working it out over a period of years and saying, okay, here is this test that we've come up with, this critical machining test. It's much better attested than readily.
So would you say that it's like the ordinary usage, now everybody just understands based on longstanding practice that this critical machining test is the point at which frame or receiver?
Correct, and it's not that we're deferring to that, but that's the best evidence we have of what this means.
In ordinary usage, an object that is created to perform a function may still be called by the name that's attached to that object, even if it is not completely functional. Isn't that what this gets at?
I don't believe that this is what gets at, and there are two provisions here.
Well, before you walk
yes.
away from that, let me give you an example.
Okay.
Suppose I see that my neighbor is restoring a classic car, but he's taken out some critical parts. And then someone says, well, what is that? And I might well say, well, that's a 1957 Thunderbird, even though you couldn't drive it, and it would take some work to make it do the thing that it was originally created to do. So isn't that the essence of your backup argument? The thing must still be such that one would call it a frame or receiver, even if it is not fully ready to be functional as a frame or receiver at this time.
Yes. So our primary argument is it would have to be, and so I think you could think of a situation with a car, and you ask your neighbor, can I borrow your car? And you give him the car with the engine taken out. They would probably say that's not a car. But also the backup, yes, is that at some point, something is a car, even if it can't currently perform that function.
So what exactly does the critical manufacturing, critical machining test involve? What does that mean? To explain it to somebody who, to a layperson.
Yes. So a frame or receiver is basically the part of a firearm that holds the components that allow a firearm to function. So the firing mechanism, the trigger and such, and the sealing component that makes sure that the barrel is sealed off so that the round goes out of the barrel and the energy from the explosion doesn't go elsewhere. So what the critical machining operations test was, okay, we're going to focus on the parts of the frame or receiver that either have the holes drilled or material removed that are going to hold those parts. And we're going to see, have those operations been performed or been performed to some degree. And if they have, we're going to say that's a frame or receiver. And what's important is that this solves the one hole in the AR-15 lower problem, because the critical machining operation for that machine gun receiver would be drilling that final hole. So until that final hole is drilled, or at least indexed, as the government has indicated, that critical machining operation has not taken place. But if the question is readily, then it would be hard to see, well, how it could be readily in this context and not readily in the machine gun context.
So you've presented the court with the critical machining alternative, and you say you have these two alternatives. The agency has presented yet another way of going about this. Do you concede that under a facial challenge like the one that you've brought, your task is actually to demonstrate that your alternatives are the only permissible ones under the statute?
Well, I think it's under a rule of party presentation. We've presented the court with the alternatives that have occurred to anyone. So I think these are the best alternatives that have occurred.
So you see the question as what is the best alternative? And the court is just supposed to say, we have three options here. Which one do we think the best? The agency didn't pick the best. It's ruled stricken.
Well, I think we actually don't have that. I think our burden is to show that the agency's is wrong. Maybe we don't have the right interpretation. But if their interpretation is incorrect, then they're asking the wrong question.
But by incorrect, you mean that they don't have the authority under the statute to reach that? It's inconsistent with the statute?
Correct. If frame or receiver does not include items that may readily be converted to frames or receivers, then this rule is beyond their authority, regardless of what frame or receiver does mean. So they've gone beyond their authority. And so, we've presented the courts with two alternatives that we think are better interpretations. But the key point here is that the agency's interpretation is incorrect.
Do you believe that a weapon that has been disassembled, a firearm, a gun that was once fully operational, everyone would agree was a firearm, it's disassembled, as sometimes happens, maybe even after a crime, is that still a firearm or no, under your view?
Yes, and for two reasons, if I could give it. So the first reason is that we'll have a frame or receiver. So that's what Congress put in the statute to ensure that would be a firearm. In my hypo, the frame or receiver is not in the box. Oh, then no. If you don't have the frame or receiver, then no, it's not a weapon.
So all that matters really is B, the frame or receiver.
Well, that is how the statute is structured, and part of that may be due to statutory history. So before this statute, the definition was any weapon that is designed to expel a projectile by the action of an explosive in any part or parts of any such weapon. And I think
But what's all that language doing in there if all that matters for the purpose of the definition is that it has a frame or receiver?
Well, and so what I was going to say, Your Honor, is that Congress was working from that background, and they said, okay, we're going to alter the definition of A to include readily convertible weapons, and we're going to alter the definition of B instead of including every part to focus on a particular part, the frame or receiver, and it's the frame or receiver of any such weapon. So it really could, so I think that explains, that's why it's structured that way. It's maybe not the most straightforwardly structured statute, but it could be the frame or receiver of, and then insert A. instead of any such weapon. That's really how the statute is structured.
I'm
The frame or
sorry,
receiver is
could you
key.
clarify for me what you mean? Assume that there's all the parts of a gun and a weapons kit with all the parts of the gun, but the receiver or the frame has a hole missing. So that's the weapon
Right,
parts kit.
right.
Is it your position that under A, assuming we were to find that readily convertible does include some drilling, some holes, et cetera, just like a starter gun to make it a weapon, would that be covered under A?
I don't think, I think whether it would be covered would turn on the interpretation of B. If the court accepted our backup argument,
Okay.
and
So
that
what
critical-
you're taking out of B, readily convertible, and also taking it out of A.
no, we're not taking it out of A because, and it's because of what A was meant to cover, and that is these starter guns that practically were guns. They had handgun frames,
You have
but the barrel had
You
to
have
be.
no quarrel with the proposition that the agency can, within whatever the statute limits it to do, to determine what makes a completed or nearly a completed frame or receiver.
I'm not sure I understand the question, but we have no quarrel as the alternative we presented with the critical machining test and the hypothetical Your Honor presented with a single hole
Thank you,
that
counsel.
likely would meet that test.
Anything further? Good. Thank you, counsel. Rebuttal, General?
Thank you. Mr. Chief Justice, I want to begin with the question you asked about why manufacturers would leave these holes undrilled. You said, what is the purpose? My friend responded that it's to create a kit that hobbyists can put together. I think that that's a questionable proposition, given that if it only takes 20 minutes, the hobbyist is probably not going to get his money's worth and won't actually have the experience of building a gun. But I also think it's contradicted by the facts on the ground, because what the evidence shows is that these guns were being purchased and used in crime. They were sold to be crime guns. There was a 1,000% increase between 2017 and 2021 in the number of these guns that were recovered as part of criminal investigations. And it makes perfect sense, because the whole reason why you would want to get your hands on one of these unserialized, untraceable firearms is if you are a prohibited person or you want to use that gun in a crime. And more fundamentally, if there is a market for these kits for hobbyists, they can be sold to hobbyists. You just have to comply with the requirements of the Gun Control Act. Someone who is lawfully allowed to possess a firearm and wants to build it can purchase that kit if they undergo a background check. And so if there is a market for these products, they can operate under the statute. The evidence shows that actually the market for ghost guns essentially collapsed after this rule was permitted to go into effect, which I think just underscores what was evident all along. The reason why you want a ghost gun is specifically because it's unserialized and can't be traced. On the question of a frame or receiver, Justice Sotomayor, you asked questions about exactly what standard governs here, and I think it's helpful to break down the interpretive question into 2 points. The first one is, this is an undefined term in the statute. Does it require the weapon to be functional? We think the answer to that is no. If you are missing a single hole, then you can clearly recognize that as an unfinished component part of a weapon, and it is readily convertible to function, and that fits within the plain dictionary definition of what a frame or receiver is understood to be, no different than a bicycle missing pedals or a tennis racket that is sold unstrung. We have a picture of this on page 34 of our brief, what these frames and receivers look like, and it's hard to know what else to call them because they look exactly like the principal structural component of a gun. But that just raises the follow-on question, okay, if it doesn't have to be functional, exactly what standards should you use to measure when it is a frame or receiver regulated by the statute? And there are good reasons why ATF focused on whether it can be readily convertible. First, that's most consistent with how Congress has approached this issue when it has defined terms under the federal firearms laws. That's the standard that Congress itself uses to mark the terrain of what products are regulated. Second, there is a consistent agency practice here of applying that readily converted standard. My friend several times tried to suggest that the 50-plus years of agency practice instead focused on whether it has reached a critical stage of manufacture, but that's ignoring the actual elements cited in the classification letters. They looked not just at what had been done to the gun, but what steps remained, how much time it would take to perform those functions, what equipment you would need to make that functional, what kind of skill you would need, and whether there are other parts. None of those elements go to what has already been machined on that particular frame or receiver. Instead, they are centrally relevant to whether it can be readily converted to function, just as the agency has said all along. For a third reason, that means that this is a standard that is familiar in the law and familiar to industry. I think it's really notable here that we don't have the major gun manufacturers suing us about this final rule. And the reason for that is because this readily converted standard is the one that has governed their conduct ever since the Gun Control Act was enacted. That also means that there is a stable body of judicial precedent and agency practice to draw on here in further answering concerns about whether particular types of products will be regulated, which I think Justice Kavanaugh also answers some of the concern about how the regulated parties will know whether their conduct falls within the scope of the law. Finally, in thinking about respondents' primary argument here, which is that a single undrilled hole is enough to exempt a product from regulation, I think the court doesn't have to blind itself to the practical ramifications of that rule. The agency's interpretation reflected in this rule is the status quo. It is how the law has been applied over 50 years. And if this court now says that one undrilled hole is enough to exempt these products from regulation, then that is going to be a sea change in how the Gun Control Act is implemented. At that point, it can't serve out its function because all manufacturers everywhere could simply exempt their products from regulation through that simple expedient. And that means that going forward, all guns could become ghost guns. This court said 200 years ago in the Emily that you don't have to interpret a statute to be self-defeating like that if there is a plausible alternative construction. Our construction is not only plausible, it is the best reading of the statute, looking at text, context, purpose, and history. So I'd encourage the court to say that and reverse the Fifth Circuit.
Thank you, General Counsel. The case is submitted. We'll hear argument next in Case 23-621, Lackey versus Stinney. Ms. Magley?
Mr. Chief Justice, and may it please the Court, the prevailing party is the party who wins the lawsuit, obtaining a final judgment in its favor, or, at least, a party who obtains a ruling that the defendant is liable on the merits of one or more claims, such as a summary judgment or a judgment as a matter of law. A preliminary injunction is neither a final judgment nor a determination that the defendant is liable on the merits for violating federal law. It is simply a threshold prediction of the likelihood of success based on a truncated record and an initial, often hasty, assessment of the law that may well prove to be faulty as the case proceeds. It provides no enduring relief. By its nature, it is a temporary procedural order that dissolves upon final judgment. A preliminary injunction, therefore, does not make a plaintiff a prevailing party within the meaning of that legal term of art, and thus no statutory exception to the default American rule applies. Legal dictionaries at the time Congress enacted Section 1988 defined prevailing party based on whether the party had successfully maintained its claim looking to the end of the suit, not on its degree of success at earlier stages. This court's precedent similarly provides that liability for fees and liability on the merits go hand in hand. The court should therefore adopt a bright-line rule serving the critical interest in ready administrability that a preliminary injunction does not make a plaintiff the prevailing party. I look forward to this court's questions.
Can a consent decree or default judgment support a prevailing party?
Yes, I think so, Justice Thomas. Under this court's precedent, the court held in Mayer that a consent decree qualifies, and it suggested in Kurt saying that a default judgment would also qualify, and a default judgment and a consent decree are similar in that they're both situations where the court has not ruled on the merits, but because the defendant has waived or forfeited a challenge to the merits, the court nonetheless enters a final judgment in the plaintiff's favor.
But I thought your argument hinged on a court ruling in favor of, on the merits, in favor of the prevailing party.
For an interlocutory ruling, that's correct, Justice Thomas, but it's either an interlocutory ruling or a favorable final judgment. If a party has a favorable final judgment, it has won the lawsuit, and thus it falls within the definition of a prevailing party for that reason.
What do you do with the formulation by your friend, which is the question is whether they got as much relief as they needed? I wonder why that doesn't fit under the prevailing party language. In other words, I don't know what that would be. Like they want to do a parade tomorrow, they get a preliminary injunction, the parade goes forward, and they haven't gotten a final judgment, but they don't need a final judgment.
A couple of responses to that, Mr. Chief Justice. First, it's not sufficient for an interlocutory order because there's been no determination that the defendant has violated federal law or that the plaintiff's claim actually succeeds on the merits. And second, at least certainly in a situation such as this one, the plaintiffs got what they wanted, but ultimately they got what they wanted because the Virginia legislature repealed the statute. So they didn't ultimately get the relief that they wanted from the court.
Well, but they did. They got interim relief. They had their licenses restored, and they had it restored without paying a fee. And they drove around, despite the existence of the statute, for I think 16 or 18 months, whatever it was. So it was final. It was never reversed, dissolved, or otherwise undone by a final decision, which is all that Sol said. And we have never required a final judgment in at least two cases, Hanaran and Texas State Teachers. We said you can award interim fees. So final judgment has never been required. All that's required is, did you get a judgment in your favor or relief in your favor that hasn't been reversed, dissolved, or otherwise undone?
A couple of points in response to that, Justice Sotomayor. First, Hanrahan did say that an interim fees could be available, but it said only when a party has prevailed on the merits of at least some of his claims, because only in that circumstance has there been a determination of the substantial rights of the parties, which Congress concluded was necessary.
But I don't know why a preliminary injunction doesn't do that, because under Winter, we have recently said that there has to be a finding of a likelihood of success on the merits. So there's been a finding of likely success on the merits, and there's been relief granted. So that's the only thing that's required by law to get that relief. That's winning on the merits of a preliminary injunction.
Under Winter, a party does have to show a likelihood of success on the merits, but as the court said in Kamenish, it's improper to equate a likelihood of success on the merits with actual success on the merits, both because substantively it's simply a lower standard, and also significantly because of the procedural differences between a preliminary injunction and an actual determination of the merits. For instance, a court can consider inadmissible evidence at a preliminary injunction.
Well, it's true that it's only a likelihood of success, but, you know, a likelihood of success is better than an unlikelihood of success. And we have to decide who's going to pay these fees. And these parties they got the likelihood of success judgment, and they got everything that they wanted in the interim before the legislature acted. And when the legislature did act, I mean, it's almost, this goes back to Justice Thomas's first question, it was almost in the nature of a unilateral settlement. It's kind of like a we give up, right? So you have all those things. You have the likelihood of success finding. You have the fact that they get everything that they need and want in the interim period, and then the whole thing is brought to a close by the legislature saying, essentially, we give up in the same way that it would in a consent decree case, even without the final imprimatur of the court. Put all of that together, I mean, why shouldn't fees go the other way here?
I disagree with that, Justice Kagan, for a number of reasons. And first of all, I don't think it's correct to say that if a legislature changes a law when a lawsuit is pending, that's equivalent to a legislature giving up or agreeing to a consent decree. A legislature may choose to change a statute for a number of reasons, including because it concludes that the statute is simply poor policy, and that determination should not make the government subject to an award of attorney's fees. Indeed,
but it's not that determination that's making them subject to the attorney's fees, right? I mean, what's making them subject, I think, is the fact that before that determination in this situation, they presented their arguments to the court as to why they believed that they were entitled to relief, and they received that relief. I mean, you talked about the standard of what is a prevailing party, and you originally asserted that it was a party who wins a lawsuit, but the court has spoken in, I don't know how to pronounce this case, is it Lefamine, that a plaintiff prevails when a court order grants him actual relief on the merits of his claim that materially alters the legal relationships between the parties by modifying the defendant's behavior in a way that directly benefits the plaintiff. And like Justice Sotomayor, I don't understand why a preliminary injunction couldn't satisfy that standard.
Because a preliminary injunction is not a determination on the merits.
But it is. When you think about the difference between merits determination and non-merits determinations, we're talking about determinations of, preliminary threshold issues like jurisdiction, right? A jurisdictional determination is not a determination on the merits. That's what we've said. But to the extent that under Winter, the preliminary injunction touches on what the court thinks about the merits of the actual legal claim, it is making a determination. Now, it's not a final determination on the merits, but it is a determination on the merits.
It touches on the merits, certainly,
Yes.
Justice Jackson, but it's not a determination of the merits.
But he got relief based on the court's initial determination on the merits.
But the essential purpose of a preliminary injunction is not to provide a remedy for a violation of a law, but to protect the court's ability to grant effective relief at the close
What
of
about
a
the
case.
Chief Justice's example? In that situation, the absolute purpose is the parade is tomorrow, and what I want to do is I want to be in it, says this group. I need a PI.
Certainly in that circumstance, if a party chose to seek a consolidation of the merits with the preliminary injunction under Rule 65A2, then there would be an actual determination about whether the defendant had or hadn't violated federal law, and that could then qualify. But otherwise, if you imagine in Seoul, for instance, that the plaintiff there had only wanted to hold the one demonstration, then under that theory, the plaintiff would have been the prevailing party.
But didn't Seoul leave open that very question? I thought Seoul was about whether parties can be divested of their prevailing party status if eventually it goes on and the court says, no, you did not win. But in the interim, if they win the preliminary injunction, at that moment, they're a prevailing party, and they continue to be unless and until they are reversed, in a sense, by the final judgment.
Seoul did leave that question open, Justice Jackson, but it also said that the temporary fleeting relief was insufficient and that enduring relief was necessary. And when that's combined with Buchanan, which holds that that enduring relief has to come from the court, then a preliminary injunction that's dissolved because a case is mooted by a non-judicial alteration, here the Virginia legislature deciding to repeal the statute, does not qualify to make the plaintiff a prevailing party.
Suppose that in the litigation on the issue of a preliminary injunction is very extensive. Lots and lots of attorney hours are burned up, and at the end of all that, the district court issues a preliminary injunction and makes factual findings that are going to be hard to reverse on appeal, and then the government says, wow, we're facing the potential of a really heavy hit of attorney's fees, so let's just throw in the towel and change the rule or whatever is being challenged.
In a lot of cases, Justice Alito, the case is not going to become moot for a number of reasons, even if the government changes its conduct prospectively. The voluntary cessation of the challenged conduct is not typically going to moot a case under the voluntary cessation exception to mootness. And if the government wants to overcome that, it has to meet a demanding standard, as this court recently held in the Fickrey case. In many instances, civil rights suits the plaintiffs can also seek damages, and that is also not going to be mooted by a change in the rule going forward. So a lot of the time, the defendant may well, after a preliminary injunction, if it concludes that its further factual development, further legal development is unlikely to change that analysis, the defendant may well then say, well, I'd better settle, or the fees are going to simply keep accruing. But it's not the case that a government can simply decide at any stage of a case that it wants to moot it.
Well, didn't this statute render the case moot?
The statute did render the case moot.
And couldn't a state do that, with respect to all kinds of different cases? I mean, we had a case a couple of years ago, New York State gun regulation. You can imagine that sort of thing. It wasn't the case in that a preliminary injunction was issued, but imagine that it had been. And then New York State changes its gun law, and it leaves everybody kind of high and dry, even though they've won the only thing that's been at issue, and maybe after very extensive litigation, as Justice Alito suggested.
A few responses to that, Justice Kagan. First, a legislature's decision to repeal a statute shouldn't be considered a form of gamesmanship. Among other things, the legislature is not the defendant in a civil rights suit. The defendant is an executive official. The legislature is a separate and independent branch of government, and the defendant has no control over whether the legislature decides to act or when the legislature decides to act. In addition, even a legislative change is not always going to moot a case. Indeed, the dissenting justices in the New York rifle case set forth a number of reasons to believe that case as a whole was not moot, including the availability of damages and the fact that the legislative change may not have completely resolved the plaintiff's claims there, even though this court found it more appropriate to remand given the way the legislative change had changed the questions presented that the court had initially granted.
I think the problem that I'm having is with your evading the essence of the question, which is that the money has been spent. And the issue is who bears the cost of that expenditure. And why should it be a plaintiff who has received relief, all the relief that he or she wanted, and is now stuck with paying for that when it was the other side and one of its agents, whether agents or co-legislative body or executive body who gives up and changes a regulation, decides to make a change? Why shouldn't the plaintiff receive some recompense, assuming, by the way, that they have done enough to receive it? I mean, one of the things about prevailing party is that it's not automatically granted. There's discretion in the courts, and the courts decide how much effort you really put into this and adjust the fees according to those factors.
A few responses to that, Justice Sotomayor. First, it's not correct to say that the plaintiffs received all the relief they wanted from the court. They received all the relief they wanted from the legislature's repeal of the statute.
No, but we've said that you can get $1 in nominal damages, so you didn't get all the relief you wanted in a lawsuit, and you're still a prevailing party. So when I use the word all, I mean all that they wanted in this particular proceeding, this preliminary injunction. They wanted their license back, and they wanted to keep driving their cars without paying a fee to do that. And they got that pending the litigation.
Fundamentally, it is a problem with the nature of the relief rather than the amount of the relief. And the problem is simply that there's been no actual determination on the merits, and there's been no determination.
You started by answering Justice Thomas by saying default judgments and consent decrees are not determinations on the merits. So that we have already said is not necessary.
Is not necessary in the context of a final judgment, Justice Sotomayor, but as Hanrahan says, in the context of an interlocutory order, a party must have prevailed on the merits of at least one of his claims, and a preliminary injunction is not that because it requires no determination that the defendant has violated federal law.
Thank you, counsel. Just briefly, is your position, does it encourage wasteful litigation? In other words, if you're you get your preliminary injunction, but you have a lot of attorney's fees, don't you have an incentive to go forward for a permanent injunction, even though, I don't know if they'd be mootness issues or standing issues, but isn't that a bad consequence of the position you're advocating?
Ultimately, Mr. Chief Justice, I think petitioner's rule is the more judicially efficient one. Respondents' rule will create a number of perverse incentives, including incentives on defendants to avoid mootness by freezing challenged rules in place. And while it's true that petitioner's rule may lead plaintiffs to try and avoid mootness if a defendant concludes that further factual or legal development is unlikely to lead to a change in the preliminary injunction analysis, the defendant's going to have a very strong incentive to settle after the preliminary injunction so it doesn't continue to accrue the fees.
Thank you. Justice Thomas? Justice Alito?
If there is very strong evidence that the government changed the law primarily to avoid the payment of fees, could a court, as a matter of equity, award fees?
Under a bad faith theory, I think if it was a change, a legislative change, again, that's not the defendant, and it usually hasn't been attributed to the defendant. If you're talking about, say, a city changing in its ordinance when the city is the defendant and the court concludes it's done in bad faith, then perhaps that equitable exception, aside from the statutory exception, could apply.
Okay, one other question. as I understand it, your position is that a prevailing party must obtain a conclusive ruling on the merits or a final judgment in its favor. What is the difference between those two categories?
In most cases, there won't be a difference between those two categories, but a difference can arise, particularly in complex remedial disputes. And Bradley, which is discussed in Hanrahan, is a good example of this. Bradley was a school desegregation case, and at the time the court awarded interim fees, there had been a determination that the defendant had violated the 14th Amendment, and a permanent injunction had been entered, but the court had actually retained jurisdiction for further proceedings to see if modifications could be necessary after it saw how the permanent injunction operated in practice.
Thank you.
Justice Sotomayor, any further? Justice Gorsuch?
One question about your answer to Justice Alito. What would be the basis for that equitable jurisdiction? I mean, I understood your position to be formalist and kind of focusing on the language of the statute, and the two definitions that you just offered kind of go to that formal definition of conclusiveness, and that there might be reasons why we treat a consent decree as the equivalent. But where does this equitable authority come to? It seems like it pretty significantly undercuts your argument.
It would not be a fee award under Section 1988 at that point, Justice Barrett, but as discussed in Alyeska Pipeline, prior to the enactment of the fee-shifting statutes, there were common law, very limited common law grounds for fee shifting recognized, one of which was a party acting in bad faith.
I read your brief as asking for categorical preclusion. In other words, you're saying PIs can never as opposed to sometimes. Is that right?
That is correct, Justice Jackson.
Even though, has any court ever held that? I thought all the courts said it, maybe, sometimes.
The Fourth Circuit rule prior to this case was a bright line rule.
But then they changed it.
But then they changed it.
For those of us who think about legislative history, what do you do with the fact that in Hanrahan, we said that the legislative history demonstrates that a plaintiff may sometimes prevail without having obtained a favorable final judgment, and we were looking at the House report that seemed to say that.
We agree under our rule that a final judgment is not always going to be necessary under the statute, but there has to be a determination of liability on the merits on at least one claim. And that may not be a final judgment, for instance, in a case where liability proceedings have been bifurcated.
Right, but I think in this report, they weren't comparing final judgments to these other scenarios. They were saying you could do it as an interim matter. So the House seemed to contemplate that you could have interlocutory prevailing party status.
Well, Hanrahan notes that the legislative history discusses interim fees with regards to two cases, one of which was Bradley, which I discussed, and the other of which was Mills, which involved this court holding that partial summary judgment on liability should have been granted in the plaintiff's favor. So I don't think that the
You don't think it counts? Okay, thanks.
Thank you. Mr. Yang?
Mr. Chief Justice, and may it please the Court, prevailing party is a long-standing term of art that means the party for whom judgment is entered, which turns on whether at the end of the suit the plaintiff has successfully maintained at least one claim for relief. This Court has repeatedly determined that liability on the merits and liability for fees go hand in hand, such that the plaintiff must obtain at least some relief on the merits of his claim to be a prevailing party. A preliminary injunction reflects a preliminary determination, not a final determination, that rests on a finding of a likelihood of success on the merits, not actual success on those merits. Soule v. Weiner thus determined that a preliminary injunction's tentative character makes a fee request at that initial stage premature. And after that, in this case, the case became moot due to legislative action that Buchanan teaches does not confer prevailing party status. Now, while a plaintiff whose case is dismissed might not lose on the merits, Section 1988 does not award fees to non-losing parties. It requires prevailing party status. I welcome the Court's questions.
Do you think that the statutes in which Congress requires that there be a final order before you can before you can have a prevailing party? You think that's just simply superfluous?
No, I don't. There's only one statute, by the way, that predates Section 1988. It's Section 1617, which is discussed by the court in Bradley. All that does is clarifies that you don't need a true final judgment that ends the case. A final judgment normally is one that resolves all claims and terminates the case. In the context of Section 1617, that's in the context of school desegregation injunctive orders. And in that context, you often will have a final order, which is even if it doesn't resolve all claims, but it's final, it's on the merits, you're granting relief on the merits, but the injunction may need to be tweaked as we go along, because just any kind of complicated institutional injunction is going to have to be tweaked. That's all Section 1617 requires. It does not change the normal understanding of prevailing party, which a prevailing party is one who succeeds at the end of the case because they obtain judgment on at least one claim.
Counselor, you say, if I understand it, you don't have to get final judgment on all the claims, right? If you prevail on one. Now, if you prevail on one, can you get the attorney fees that are associated with 2, 3, and 4?
No. There's multiple questions in attorney's fees cases. The first is whether you're a prevailing party. You have to succeed on at least one claim on the merits.
Right.
The question then goes to how much fees. Usually it's a reasonable fee award, and the reasonableness of the fees, you would look more granularly to determine whether the issues were intertwined or not. If they're completely separate issues and you lost on them, generally no, you don't get fees for those.
What do you do with the case that Justice Jackson posed, which is common? I want to participate in this protest, this parade, and only the passage of time moots the case. You've gotten all your relief. Nothing you've done or someone else has done has changed it. You got all the relief you really wanted. I wanted to protest.
Well, you did not get relief on the merits. Now, I think a lot of the questions—
We keep going back to the operative question here, which is we've repeatedly said you don't need a final judgment. You don't need a determination of the merits. You can have a consent judgment. You can have this. There has to be a different sense.
I don't think that's quite right. The legislative history says you don't need a final judgment following a full trial on the merits. That means you can get a final judgment at an earlier stage through summary judgment before you go to trial, through, for instance—
That's not a final judgment. You get
yes, summary judgment is a final judgment.
Not until you appeal it, not until the whole case is litigated. You get a judgment, but not a final judgment.
If a court grants summary judgment, it is a final judgment if it's on all the claims. If it's summary judgment on part of the claims, then it's subject to revision, so it's not truly final. If it's injunctive, and you grant summary judgment and then award injunctive relief, well, that's final because you're actually awarding merits relief at that point.
So, for example, in Chief Justice's hypothetical, after the parade, I could ask for a trial on the merits in accompanying the PI, and a final judgment could be issued at that time.
That's correct.
That happens all the time. It happens from—
It happens, but sometimes it doesn't because it's—
And sometimes it doesn't because I might want to go ahead and litigate it because I'm concerned about the same thing in the future. And I might want, for example, a declaratory judgment. And I could issue— I could
Or the
litigate
parade
that.
may be annual. A lot of these
Maybe annual,
parades
and
are
I want a
annual parades.
prospective injunction going forward.
Yep.
And then we would have a final judgment on the merits, on
Correct.
at least that claim on which you would be prevailing.
Correct.
Right?
Correct. And I also want to address just a more general point, which is some of the questions were like, well, so their fees have been incurred. We've got to allocate them. Who do we allocate them to? Well, that's answered by the American rule. The American rule is each party, win or lose, bears their own fees. And this court has made clear that you need express statutory authority to depart from that rule.
And isn't that the statute we're talking about here? Right.
Yes, the statute uses a term of art that's existed in statute since at least— American statute since at least 1853.
Right, but it is trying Congress to give us an exception to the American rule. And the question is, what is the scope of that exception?
But Congress didn't go all the way. Congress adopted a term of art which had
prevailing party.
settled
Can I just
meaning.
ask about Justice Gorsuch's example? What if I don't want to spend the time and additional money to litigate this through to a declaratory judgment or a future? What if I just want to march in the parade tomorrow? I'm a religious organization, for example. I don't I agree with traditional marriage, and tomorrow is the LGBTQ parade, and I want to march in it. I want to be able to be there. I'm not making a whole thing out of it. Yeah. I get that. I go to court and I argue the merits of my entitlement to be able to do that, and the court says, as a preliminary matter, we don't have a whole trial yet, I think you are going to win. So I'm giving you an injunction, and you get to march in the parade. And I do. And then I'm done. I say the case is mooted because really the relief that I wanted was the ability to march in the parade tomorrow. But I did have to pay an attorney to be able to convince you, court, to give me the relief that I requested. I guess I don't understand why, under our formulation of the test for prevailing party in the Lefemine case, what we say—
That was a permanent injunction.
I understand it was a permanent injunction in that case, but I'm asking you, we set up a test for when you are a prevailing party, and the question is, why doesn't that test also cover preliminary injunctions like the one that I talked about?
Part of that test is a judgment on the merits. And this is not a preliminary injunction, is a tentative determination that does not control anything later in the suit. It's only for the PI stage, only to adjust the parties' relationships during the suit.
Mr. Ms. Mealy said that she didn't know of a circuit that had accepted this categorical position. If it's a preliminary injunction, there are no fees. Do you know of any circuit that's accepted this categorical position?
Well, that was the Smith rule prior
to it being changed.
But this court granted cert on unanimous.
There's a uniform rule. You don't know of anything, any court that's gone the other way. And you know what? Well, it's an interesting thing. It seems that this comes up all the time. And it seems as though it's come up frequently in recent years. When I was talking to my clerks about this, several had confronted this issue with respect to COVID litigation, where people went to courts and they asked for injunctions from various kinds of COVID policies. And then, in the end, those policies were changed or were scrapped or were abandoned in some way. So it seems as though there's quite a lot of recent law that cuts against you here from circuits like pretty much all across the U.S.
Well, the circuits are not uniform. Some of them look to, for instance, the Fifth Circuit looks to why the mooting event occurred. But my point, I want to make 2 points. One, this court already addressed the strategic mootness question in Buchanan and addressed that in 4 different factors. There's 2 other factors. I want to address 2 of those first, and then I'll go to Buchanan. One is that Congress has struck a balance here, that there is reason for caution before abandoning what this court has described as the crucial connection between liability for a violation of federal law on the merits, finding on the merits that you violated federal law, and attorney's fees. And there's reason to pause before doing that. Congress has sometimes been more generous with the government, but this statute covers both private individuals and non-federal actors. Secondly, going to Buchanan, there's a cost of deterring federal government action from being voluntarily changed when it may be lawful. Litigation often puts a spotlight on a practice that might not be the best policy, even though it's lawful. And the court in Buchanan recognized there's a cost to deterring that kind of good government change. Secondly—
Okay, I don't think that's what I was asking about. I was asking really, do you have any law out there on your side?
We have a term of art that has gone back in this court's decisions, and I think that the courts of appeals just have not been faithful to this court's decision.
Well, that raises the question for me. Why do you think they've been not seeing the light?
Well, I think sometimes as a policy matter, you might decide, hey, this I don't like this outcome. I think some of the courts, and I acknowledge that there might be some cases like that, but that type of policy call is for Congress to make. So in Buchanan, when the court rejected the catalyst theory, Justice Ginsburg dissented and said, hey, look, there's one specific area that's really problematic, FOIA. Congress reacted and did a targeted response to FOIA. This really goes to the appropriate separation of powers here. Congress adopts a statute that has a term of art that goes back quite some time. This court has repeatedly determined that merits determination, determination of liability on the merits is crucial to then making the defendant liable for fees. Congress.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
The respondents argue that there is a historical background of a venerable, equitable tradition of awarding interim costs, including for a preliminary injunction, and that, if accepted, would perhaps undercut your historical argument. Do you want to say something about that?
There's 2 points I'd love to make about that. First, this court already resolved that argument in Alaska Pipeline. There was and it was actually Justice Marshall's dissent. It was based on equitable principles. But what the court decided in Alaska Pipeline is that the American rule is each party bears its own cost. There are certain discrete common law exceptions that have evolved at equity. For instance, the common fund exception. You get a fund, it would be you would unjustly enrich the people who benefit unless they pay your fees. That's a fee sharing, not fee shifting. Bad faith attorney's fees is another one. Contempt fees is another exception. But the court did not say equity, it's all, whatever you think is equitable. The court recognized that there are very discrete limits. And I think that's illustrated by the only case that they cite as supporting a PI fee award, and that's Clancy versus Gebb. In that case, it was not based on the temporary injunction that was issued on the day the suit was filed. The court said it was based on the trial on the merits that sustained the cause of action for an injunction. Now, after the trial on the merits, the court didn't grant further injunctive relief, and that might be a problem, but it certainly does not stand for the proposition that a TRO or a PI gets you prevailing party status. There was a final adjudication on the merits of the cause of action.
Thank you.
Justice Sotomayor?
Just to be clear, Buchanan, there was no court-ordered relief whatsoever, correct?
That's true.
And as I read the decision, that was mostly the focus of the decision.
Well, certainly, the catalyst theory was, but the catalyst theory does not, we're not escaping the catalyst theory here, because the catalyst theory is embedded in this case. It is what happened with this case after.
Well, but you're claiming there is no catalyst theory because you're saying the legislature acted, or the other side is saying it acted independently. So it has nothing to do, they're saying it doesn't matter why the case ends, it just ended with a judgment dismissal of the action. It could be for mootness, it could be because the other side gave up. I got what I came for, at least in part. I got my license back. I drove for 16 months. I didn't have to pay anybody to get my license back. I won for that part of my relief. And it's never been dissolved, reversed.
But that's not what the term prevailing party has been understood, either by this court or by the dictionary definitions that date back from before the 20th century. That has required a final adjudication.
That's the problem. No, it's never required a final adjudication. It's required a judgment, but not a final one.
Well, it has. I mean, even the legislative history. This court in Hanrahan discussed the legislative history. It's all in dicta, but it discussed the legislative history of Section 1988. And what the conclusion the court drew was that interim fees, meaning before the case is finally over, were available only when the party has prevailed on the merits of at least some of its claims. And that happens when you get a final determination, maybe not a final judgment because you're not resolving all claims, or maybe because there's some ongoing litigation about the nature of the injunctive.
Thank you, Mr. Yang. We have a difference of opinion on what finality means. If all you're seeking is a preliminary injunction, that's final for that purpose.
You don't file suits for preliminary injunctions. You file suits for equitable relief, a judgment at the end of the suit. A preliminary injunction is a preliminary matter that protects the parties while the suit is adjudicated.
Thank you, counsel.
Justice Kagan? Justice Gorsuch?
Let's see if I've got it. So a PI can't be the basis for an award of fees under this statute because Sol basically says you have to look at what happens afterwards. And for all the reasons you just gave, a PI is a PI. It's preliminary. It's not okay. All right, fine. Now, so we have to look what happened afterwards. And here what happened afterwards is plaintiffs may well have convinced the Virginia state legislature to change their mind in a catalyst sort of way. Mm-hmm. The problem is Buchanan says that doesn't work either.
Correct.
All right, but Justice Ginsburg in Buchanan says, hey, Congress should fix that. And Congress did fix it in FOIA.
Yep.
And said voluntary cessation and changes, you still get fees.
So long as it's not an insubstantial claim. So
Right.
quite generous, with the government's money, of course. It's quite different when we're talking about private litigants and non-federal. I think Congress might be more reticent to creating such a generous departure from even the prevailing party standard, but it could.
It could.
It could.
And it hasn't here.
No.
End of case. That's your theory of the case.
That's our theory.
All right, got it.
Mr. Kavanaugh?
I think when the red light went on, you were in the middle of a really brilliant answer about Buchanan, and you want to finish that?
Like a preliminary injunction, it was fleeting. And I'm not sure that I recall the brilliance.
Well, I will look at the transcript and fill it in. So,
well, I was just going to try to talk about strategic mootness maybe a little bit. Maybe that's where we were going. And,
sure.
Strategic mootness, as my colleague has already answered, you've got voluntary cessation barrier, which, in your decision at Vickery, Justice Gorsuch, it's a pretty formidable burden.
I hope so.
It's a formidable burden. Damages awards, never going to moot out. And it's entirely speculative what effect this is going to have. That's what Buchanan said. Like, it's not speculative whether it's going to deter counsel or not. And I think this illustrates that. There's no data to show this. This case was started when Smith was the rule. They had no reason to expect any attorney's fees from a PI, but they took the case. So it's a little hard to say, like, there's this compelling case that, like, we're going to have a crash in civil rights era. And there's a real cost, again, to deterring the government from changing courts when that action might be lawful but bad policy.
Okay, that's good enough. Thank you.
Justice Barrett? Justice Jackson?
So here's the problem that I'm having with your statement of the case as you summarized with Justice Gorsuch. It's that it begins with Sol says that a PI doesn't count because you have to look at what happens afterwards. I'm reading from Sol. We express no view on whether, in the absence of a final decision on the merits of a claim for permanent relief, success in gaining a preliminary injunction may sometimes warrant an award of counsel fees.
Sure.
So I don't know how you can start your case with the premise that Sol stands for the proposition that if you win a preliminary injunction, you have to get to final judgment in order to be entitled to counsel
It's true
fees.
that the court reserved that, but the court also did say that it recognized that preliminary injunction was just the initial salvo. As I stated in my intro, it's the tentative character makes a fee request at that initial stage premature.
It did not say premature. It says Weiner is not a prevailing party, we conclude, for her initial victory was ephemeral. And it was ephemeral in that case because it happened to go on and get reversed.
It's on page 84 of the court's opinion. The tentative character would have made the fee request at this initial stage premature.
The tentative character
Of the
would have
PI.
made, yes, but it also says we express no view as to whether or not that tentative character in PI is enough to make you a prevailing party.
Agreed, but I think it goes halfway there, and Buchanan closes the door on that.
Thank you. Thank you.
Thank you, counsel.
Thank you.
Mr. Schmalzbach?
Mr. Chief Justice, and may it please the court, the winner of an unreversed favorable judgment and tangible relief from the court is a prevailing party under Section 1988. That is the test, which we agree with the United States that that is an appropriate test. It is most consistent with the statutory text, context, and precedent. And under that test, the winner of an unrepudiated preliminary injunction can qualify as a prevailing party. This court should affirm for three reasons. First is the text. We do encourage the court to consult those contemporaneous legal dictionaries, which do say that the party in whose favor a judgment is awarded is a prevailing party. It does not require a final judgment. And, Your Honors, if you consult the statutes that were in effect right before Section 1988 was enacted, that includes 20 U.S.C. Section 1617, which did require a final order, not merely a naked prevailing party. And my friend on the other side said that was the only such statute. It was not. the legislative history of Section 1988 also references the Communications Act of 1934, which requires not just a prevailing party, but a party that finally prevails. Congress knew how to require that sort of finality when it wanted to in fee-shifting statutes. It did not do it in Section 1988. Second, precedent. Under this court's precedent, the touchstone of prevailing party status is the material alteration of the legal relationship between the parties. Justice Thomas, to your question, why is a consent decree enough to make you a prevailing party? Buchanan answers that question. And Buchanan says that what makes the winner of a consent decree a prevailing party is that consent decree accomplishes that material alteration, just like a preliminary injunction can. Buchanan does clarify that the prevailing party has to be one who is, quote, awarded some relief by the court. That is exactly what a preliminary injunction can do, and that is exactly what our preliminary injunction did here. It forced the commissioner at gavel point to provide the relief that we requested. Third, Mr. Chief Justice, to your point, petitioner's solution when injunctions become moot is unworkable because it would force parties to slog in the many cases where no damages are at issue all the way through trial solely for the purpose of winning nominal damages. But when plaintiffs have already won the injunctive relief worth fighting about, courts shouldn't have to referee such fights over farthings.
Well, it does seem to me that the courts then have to figure out if prevailing is not going to mean final judgment on the merits for at least one claim, then it must be a pretty ambiguous thing where what constitutes prevailing. Now you say, well, in a preliminary injunction case where there's nothing going on beyond the time when the preliminary injunction does its work, maybe that's easy. But there are all sorts of other ways. If prevailing doesn't mean you actually have to win, I mean, what falls short of that?
So, Your Honor, I agree that those cases where a preliminary injunction provides 100% of the relief that you went to court to get, those are easy cases. But the only difference between a case like that and a case like this is that we were awarded only some of the relief that we went to court to get. But under Garland, that doesn't matter. Garland doesn't require that we win everything the way a parade preliminary injunction might. It only requires that you win some of the benefit sought that drew you to court in the first place.
Well, yes, I'm sorry. I don't want to interrupt you.
Please, Justice Kagan.
Yes and no. I mean, you know, if you let me give you a hypothetical, and let's take it out of this state context. Let's just say there are two neighbors, and one of them is pouring pollutants into a stream that goes onto the other neighbor's property, right? And so the injured neighbor sues, and he sues for a permanent injunction, but first he sues for a preliminary injunction. And a preliminary injunction is gotten. All right, he gets, and for the next 3 years, while the court decides the case, he has a very valuable thing, which is the neighbor has not been able to pour pollutants into his stream anymore, right? But then the court changes its mind, and the court says, we're not going to grant the permanent injunction, right? And the plaintiff says, well, I got something really significant. I got 3 years worth of a preliminary injunction, and that was fantastic. So I should get fees for that the same way I get fees for winning one claim out of 3, right? Does he get fees?
Not if he's lost on the merits.
No. So that's Sol, right?
That's Sol.
And even though, like, Sol does say, I mean, I take the point that Sol reserved this question, but Sol does sort of say you can split things up by claims, but we're not so keen on splitting things up temporally. Like if you've lost the permanent injunction, the fact that you've gotten 3 years of excellent relief is just not going to get you any fees at all, right?
That's right.
Okay. Now let's say there is no permanent injunction because the neighbor dies or, you know, the stream goes dry. All right? And so all that's left is the preliminary injunction. The court could have done the same thing, you know, if it had gotten to the permanent injunction, which is to say no, but something just sort of fortuitous has happened to stop the case. Why does the analysis change?
Because that plaintiff has gotten the relief that he went to court to get, Your Honor. And this connects to Justice Alito's question about
Well,
the
he
equitable-
hasn't, because he did go to court to get the permanent thing. I mean, the preliminary injunction was a kind of way station on the way to getting the permanent thing. But what he really wanted, this is not the single parade, right? What he really wanted was for you never, for that stream, those pollutants, never to bother him. And essentially what Sol says is because you didn't get that, you don't get that way station relief, right? And so I'm just sort of suggesting that take out the final determination and just say, we never get to the final determination because of some fortuity. Why does all of a sudden he get the award for the way station?
Your Honor, what Sol suggests is that it is losing that judicial imprimatur from the preliminary injunction that in the final order that causes the plaintiff to lose that prevailing party status. And so in Sol, you actually have a loser on the merits. And what Sol says is that preliminary injunction is superseded. The legal and factual foundation of it has been destroyed by the final order. But that's not the case if the case just becomes moot. Nothing about that preliminary injunction has been superseded. It hasn't been rejected on the merits. It remains in effect, except insofar as
How is that? I mean, the river runs dry. I came to court on Justice Kagan's hypothetical to seek an order against my neighbor to stop him from doing things. And I got a preliminary injunction, but then the river ran dry. And so the court dismissed it as moot. Now, the court has not adjudicated in a final way anybody's rights with respect to anything. And I didn't get the relief I came to court seeking. It was denied to me in the end in the final judgment. And we normally think of all preliminary orders in a case as merging into and superseded by the final judgment. And I think that's what Sol was driving at, too. So help me out. I'm stuck where Justice Kagan is.
So, Your Honor, you have not lost the foundation of that order. It's just not needed anymore. That's the distinction that Sol draws in reserving the question whether this case, where it becomes moot, in reserving that question, Sol says what is important is that the foundation, the legal and factual foundation of the preliminary injunction is destroyed in the case where you lose on the merits. But in a case where the court doesn't need, and indeed under Article 3, cannot award any further relief, there's no holding that that preliminary injunction was improperly granted.
And no holding that it was proper. It's just gone.
But while it's
moot.
While it's in effect, it grants all that relief that was needed at the time. It grants all the relief that you came to court to get for as long as you needed.
And then at the end, it disappears. It's withdrawn. It's moot. It's gone. So yes, for a period of time, for the 3 weeks when he was still alive and the river was still running, I had my nice order against him, and it made me happy. But at the end of the day, and when we think about prevailing parties, all the dictionary definitions are when the matter is finally set at rest, when the decision or verdict is rendered and the judgment entered. And the judgment in the hypothetical here is there's no case.
So, Your Honor, two things. One, we are still prevailing when the matter is set at rest. We have not been told that we are not entitled to relief. We're just told that we don't need more relief. But I would also encourage you to look at those related statutes that were in effect when Congress drafted Section 1988, which shows that when Congress wants to have a statute that requires you to get all the way to that final order, to that finally prevailing status, it knows how to do it. But Congress pointedly did not do that in Section 1988.
We also have, after Buchanan, a pretty pointed example of them saying just the opposite, right? That if we're going to depart from the American rule and allow attorneys' fees, and one can be a fan of the American rule or not, it doesn't really matter, but there it is. Congress spoke very clearly after Buchanan to vindicate what Justice Ginsburg thought was appropriate in the FOIA context against the federal government. And as the federal government points out, mightn't we expect Congress to be at least as clear when it's authorizing fees against other parties, including states?
So, Justice Gorsuch, what Buchanan did is not what we are doing here. I want to be very clear. We reject the catalyst theory. What makes us a prevailing party is that a court gave us the relief that we saw.
Yes, but we've just been through that. Yes, it granted you relief, but it could go away. And under Sol, you could lose it and still not be entitled to fees. So we have to look at not just what happened with the PI, but what happened after. And I guess that is, it's pretty hard to say that your argument really isn't a catalyst theory, but I take your point.
Counsel, I'd like to talk about the prevailing party for a minute. I mean, when you get a PI, you're not the prevailing party. The court has made a predictive judgment that you'll probably be the prevailing party. And some circuits are still using this sliding scale. You can't disregard the merits under Winters, but, you might have gotten the preliminary injunction because the equities were really strong, because maybe the pollution is running onto your property. And I mean, I have not been a district judge, but as someone who's dealt with our emergency docket, you are making those kinds of preliminary judgments in a very compressed time frame, and it's like a 51%, like as you showed, a reasonable likelihood of success. Why is that prevailing? Because a district court has made that judgment on a PI.
Your Honor, because what this court has said is that it is the relief that you earn that makes you prevailing or not. It is specifically not prevailing on the merits. That was the legal proposition that Maher v. Gagne considered and rejected. You do not have to have full litigation of the issues. You do not have to have a judicial determination that one party's rights have been violated.
Then everything turns on your answer to Justice Gorsuch. Justice Gorsuch was pressing you and saying, but that's not the relief that you're seeking, because you're really seeking a preliminary injunction. So if I disagree with you about that, then that means that you lose, because a preliminary injunction is not the relief that you were seeking. It's like a way station, it's a Band-Aid, it's something like on the way to what you really want.
Your Honor, the relief that we were seeking was an order compelling the commissioner to remove this statutory suspension from our clients' driver's licenses. And that is what we won, and it remained in effect for 16 months, and the commissioner was never told that he could resuspend their licenses under that statute.
Couldn't you have asked under Rule 65 to speed that up?
We could have asked, Your Honor, but our clients had the relief at that point that they came to court to get. And Rule 65 isn't a cure-all for this problem. That will require fuller proceedings, which we were trying to get the court to undertake, but...
Forgotten that
they
did
have a motion? Oh, sorry, just one last question. Did you have a motion for summary judgment pending? I just wanted the answer to that from you.
Yes, Your Honor. Both sides had fully briefed motions for summary judgment pending, which the commissioner asked the district court not to resolve, rather to stay the case so that it would become moot once the legislation was passed.
That was the point. You did ask for it to be speeded up, and the petitioners asked them to wait for the legislature to act.
That's exactly right, Justice Sotomayor.
I don't know why asking them to speed it up and have more process is the solution in an attorney's fees case. I mean, aren't you incurring more fees if we're going to have additional process? And it just seems odd to me that we'd be in a world in which, to avoid having attorney's fees on the lesser victory, we are encouraging additional litigation.
I think that's exactly right, Justice Jackson, and it goes to the Chief Justice's question about what sort of litigation incentives is this going to create. I don't think we should assume that state and local defendants are like gamblers on tilt who are going to be committed to litigating a case all the way through when a district court has already told them you are likely to lose on the merits. We give them the presumption of regularity, and that's inconsistent with assuming that they're going to behave in that irrational way.
Suppose you had requested nominal damages, then what would have happened?
Your Honor, our nominal damages request would have been thrown out of court because the defendant has sovereign immunity even from nominal damages claims. So that's not a solution to this problem of avoiding mootness when there's a state defendant.
All right, when there's not a state defendant, then and you had a and the party has a claim for nominal damages, but what it really wants is a preliminary injunction. It gets a preliminary injunction, and then the case is litigated on the issue of whether the party is entitled to nominal damages, and at that point the court changes its mind and says, my interpretation of the law was incorrect when I issued the preliminary injunction. Then what happens?
Your Honor, at that point we would be the loser. We would not be the prevailing party. And the judicial imprimatur underlying the order that gave us the relief for driver's licenses, that would be dissolved at that point because we had been declared the loser on the merits.
Do you think your client under those circumstances would be very depressed? Well, I got the preliminary injunction, but what I really wanted was $1 in nominal damages.
Your Honor, whether they're depressed or not, what's important is that up to that point, they had gotten the relief that they needed to that point.
Can you address the idea that the American rule should be a firm background principle and we should require Congress to speak especially clearly when it wants to deviate from that, and including the scope of how much Congress wants to deviate?
Well, Your Honor, I was with you until you got to the scope, because I agree the American rule is the background rule, but once Congress has put into place this prevailing party rule, that changes the background rule. And what this court has done in the past—
Why is that? Lots of times we will say with background principles of statutory interpretation, to the extent, not just any deviation. So why couldn't you here too say, to the extent Congress is deviating from the American rule, the background American rule, it needs to be clear?
So two things, Justice Kavanaugh. One is that that is not what this court has said. So, for example, Garland says that our test for prevailing party, we're going to use a generous formulation. We're going to look to any material alteration of the relationship. That's inconsistent with saying we're going to construe the American rule in a stingy way as to this statute. But also, I think it's strange as a matter of divining congressional intent to look to a statute where Congress says we reject the American rule in this context, and then to say, well, but we'll still construe it narrowly because that must have been what Congress had in mind. That's not a faithful way of implementing that intent.
And then relatedly, I guess, what about the separation of powers principle that Justice Gorsuch referred to and Mr. Yang referred to, which is we should really leave, when there's doubt, we should leave this to Congress to fix this. In part, the Court of Appeals story, while helpful to you in some respects, I think it's unhelpful in the respect there are all sorts of different tests out there because they're just completely at sea and trying to figure out how to handle this. Do you just want to respond to that argument?
I think they're more similar than they are different, Your Honor. Each of them rejects the categorical rule that the petitioner proposes here. And so one of the important results of that unanimous rejection is that we do know what the world looks like where preliminary injunction winners can be recognized as prevailing parties. If it were an endless parade of horribles, we would have seen that in the briefs and the amicus briefs, and we have a trickle of things that they don't like. We don't have that parade of horribles. But I also want to point out, back to Justice Alito's question about the equitable background. The equitable background is not just some anything goes rule. The equitable background, as Wright-Miller discusses in Section 2665, is actually the rule in Rule 54D, that the winner, that the prevailing party is presumptively entitled to shifting, subject to the district court's discretion not to shift fees. And what Wright-Miller says is that is the equitable rule. And the equitable rule, of course, recognizes that winning interim relief can make you a prevailing party. So it would be odd to look at a statute that plugs right into Rule 54D, which was in existence when Section 1988 was enacted, and say, we're not going to use the equitable rule that underlies this statute that we're plugging into. Instead, we're going to do something else. The equitable background confirms the rule that all of the courts of appeals have adopted insofar as they recognize preliminary injunction winners as prevailing parties.
What if you get a preliminary injunction and under your rule you get attorney's fees, okay? But then the case continues on and you lose at the permanent, you don't get a permanent injunction. You have to give back the attorney's fees?
Your Honor, what Sol says is that attorney's fees should not be awarded at that preliminary stage. Sol does say that we would wait until the end of the case to award those fees. And that makes sense because a preliminary injunction may, as in Sol, be undercut by the final judgment that rejects the premise of that preliminary injunction.
Well, if that's the case, doesn't that undermine your argument? In other words, it's a recognition that, of course, the preliminary injunction is not final, and therefore the award of attorney's fees shouldn't be final.
No, Your Honor, because our argument is that that finality is not required. We don't require finality the way we would in the Communications Act of 1934. We don't require the sort of finality that was required in the statute at issue in Bradley. So when the legislative history is addressing Bradley, it's addressing a very different statute that does require the sort of finality.
So when the statute says prevailing party, it's really saying including temporarily prevailing party.
Your Honor, I would say it means prevailing party. And when Congress doesn't want the full scope of prevailing parties to be entitled to fees, as it did in Section 1617, then it knows how to say so. It knows how to require a sort of finality.
Is another way to address the Chief Justice's question that what we're looking for is whether you are entitled to prevailing party status and that you can be deemed a prevailing party, in your view, based on a preliminary injunction win. You can. Maybe sometimes you can't. You're not saying you always are. You're just saying reject the statement that you can never be. So sometimes a preliminary win can confer prevailing party status, but the actual award of the fees that you would get happens when the case is over. At the end of the day, then the court goes back and we look how much attorney's time was put into it. As Justice Sotomayor points out, it's a, was it a reasonable fee request for that work that went into the PI?
That's just right, Justice Jackson.
And you can be divested. The reason why you wait until the end, in part, is because even though you might have had prevailing party status, in our view, your view, early on as a result of the PI, if the case continues and it's reversed, the judgment that on the merit that made you a prevailing party to begin with, then at the end of the day, when we're doing the calculation, we say, nope, you don't get prevailing party status at that point.
That's right, Justice Jackson. You can be divested if you win a preliminary injunction but lose on final judgment. You could be divested if you win partial summary judgment, which my friends on the other side suggest is sufficient for prevailing.
And your argument is that if it's mooted, if nothing else happens, you can retain your prevailing party status on the basis of that win.
That's right, because the premise of your win has not been undermined. But, Justice Jackson, you can also lose prevailing party status if you have a final judgment and you lose on appeal. It's the sort of thing that can be divested.
We've talked about preliminary injunction as a way in which you may be a prevailing party, even though you're not final. But what about a discovery dispute? What about the case turns on whether you can get access to particular documents, and you win on that? You don't get a preliminary injunction, you obviously don't get a final injunction, but you won, you got the documents, and then the case goes away, whatever, for whatever reason. Could you be awarded fees on that? You won a very significant motion.
No, Mr. Chief Justice, because what this court has said in describing what counts as a material alteration is it has to be winning the sort of relief that you went to court to get. So
you wanted those documents. That was the whole reason. I mean, obviously, it's not a statute that says you have a right to these documents, whatever the statute is. But the key to your win was access to those documents.
But getting those documents in any case I can think of, doesn't change the legal relationship between the parties outside of court. And so a good example of something that's not the sort of relief you went to court to get, consider Shohei Ohtani's 50-50 home run ball. There's an ownership dispute over it. One side files a lawsuit. The plaintiff says, I want a preliminary injunction to prevent you from selling that ball, from auctioning it off until this ownership dispute is hammered out. So winning that preliminary injunction is not the relief sought in the complaint, which is a declaration of ownership and the return of possession. It's just something that will allow the court to award relief later. That is not enough for prevailing party status in the same way that your hypothetical is not.
And of course, that's why you're saying sometimes a PI may not confer prevailing party status. That's an example.
That's an example. That's right, Your Honor.
So your position is simply PI. It's either going to be a permanent injunction or it's going to be a preliminary injunction, and those are the only two things that could entitle you to attorney's fees.
Those two things would entitle you to attorney's fees, subject to meeting the other requirements of a
Any other type of relief, it doesn't count as prevailing.
Your Honor, I go back to the same question of whether the order has created a material alteration between.
Well, in the one case, I guess I still don't understand the answer. The material alteration in my hypothetical is you have access to the documents. That's a material alteration, but that doesn't entitle you to attorney's fees.
So if the lawsuit is about ownership, possession of those documents, if you've sued for return.
No, it's not. But that's going to determine the case. It's a very important piece of evidence for whatever the underlying litigation is about. And the court rules you can get the documents, and then for whatever reason, the case goes away. You don't get a preliminary injunction. You don't get a permanent one. You don't really need it. You wanted to make these documents public, the Pentagon Papers or whatever. Does that entitle you to attorney's fees?
No, Your Honor. That's equivalent to the grant of a motion for new trial, which this court has said doesn't create that real-world material change in the legal relationship between the parties. That's just that's addressing in-court conduct that's not going to grant the relief ultimately sought in the complaint. That's the key, is the relief ultimately sought.
You keep coming to the material alteration of the parties' relationship and responding to the Chief Justice and others. I would have thought that that was exactly the argument made in Seoul and in our hypothetical that Justice Kagan and I discussed. For a period of time, there was a material alteration in the relationship between the parties. But that's not enough. It's got to be a final when the matter comes to rest. That's the implication of a prevailing party as traditionally understood, is the one who wins in the end, not temporarily. So are you really just asking, are you fighting with Seoul, which says even a material alteration temporarily that is subsequently withdrawn doesn't count, right?
No, Your Honor, we're not fighting with Seoul.
So it can't be just a material alteration. There has to be something more. And why isn't that something more the final judgment?
What Seoul says is the foundation of that preliminary injunction has to be unreversed. That foundation can't be superseded by a later
So we
order.
do have to look at the end of the case and see what the court said at the end of the case, right?
In the same way that we would with a permanent injunction. We have to see, is that permanent injunction rejected on a motion for reconsideration? Is
And
it reversed
here at
on
the
appeal?
end of the case, what the court said, forget about what happened in the world. What the court said is moot. I dismiss the case. I provide no relief to anybody.
No, Your Honor, what the court said is implicitly is...
No. No implication. I'm looking at the judgment, because I'm supposed to look at the judgment, final judgment, prevailing party, who wins at the end. The court says case dismissed.
Your Honor, what a dismissal for mootness means is that there is no more relief that the court can provide. It doesn't mean that the relief it already provided loses its judicial imprimatur, because at that point, that preliminary injunction order remains good law. It's just that the court can't order any additional relief because there's no need for it.
All right. Thank you.
What do you do with a dismissal that's Munsingware that vacates the preliminary injunction?
So, Your Honor, a Munsingware vacator might affect a preliminary injunction in the same way that might affect a final judgment. I don't think Munsingware is on the right track for what's going on here.
No, there wasn't one here, and so that's my point, which is if a district court is unsure of whether the law is good or should continue the preliminary injunction, it could vacate it.
It could, Your Honor. I would suggest that in this case in particular, Munsingware would be inappropriate because what United States v. Munsingware itself says is that this is not a remedy for a party that has slept on its rights and failed to take advantage of review where it's available. And that's exactly what happened here, Your Honor. The preliminary injunction that was entered was immediately appealable under Section 1292A. That's why it's a judgment for Rule 54A purposes. And the commissioner chose not to appeal. The commissioner also chose to avoid resolution of its fully briefed pending motion for summary judgment. So this isn't a Munsingware case, even if it were
I'm not saying that. I'm just asking the question, which is, if a court doesn't believe that it should continue an injunction, it'll vacate it, correct? A preliminary injunction.
Yes, and the court could, of course, decide that it's not appropriate to have it for legal or factual reasons. And at that point, you would lose that prevailing party status.
Well, when you dismiss a case, the PI disappears. What's the difference? It's merged into the final judgment. Do I need to say I withdraw my PI? No. District judge says case dismissed.
Your Honor, because I keep coming back to the touchstone, which is that material alteration.
Yes,
you went to
but
court.
we went through that. It has to be at the end of the day, the material alteration. It can't be the temporary one because Seoul tells us it can't be. Because what happens later matters. And so it has to be material alteration at the end of the case.
Your Honor,
do we agree on that much?
We do. We do look to the end of the case because you can lose that prevailing party status. But I suggest that it is not the case that a party who has won 100% of the relief you went to court to get is not a prevailing party. And that's the implication, is that if you only look to mootness without more and that's the end of the game, then a party who has the football coach who's gotten a preliminary injunction, letting him pray at the championship game only, he's the prevailing party under any meaning of that term and should be recognized as such here.
Counsel, I see your red light is on. Justice Kavanaugh? Justice Thomas?
Just as a recap, what's your definition of prevailing party?
Your Honor, it's the winner of a favorable judgment and tangible relief from the court, and the unreversed favorable judgment that's never repudiated.
So I still don't understand then your answer when the neighbor dies. It's still unreversed, right?
Yes, and that neighbor has gotten the relief he went to court to get. Not all of it, and to be clear, the fact that you're only a partial winner must be considered when the district court is deciding the amount of reasonable fees. But yes, as long as you are the winner of the relief you went to court to get, and the district court or the Court of Appeals never says that you are the loser, you're the prevailing party.
Is there any other interlocutory relief that could support prevailing party other than preliminary injunction?
Your Honor, it's possible if an appealable order, a judgment, such as in rare circumstances, stays can be appealable if they are changing the party's legal relationship in the way that this does. But Congress really did single out preliminary injunctions in Section 1292A for this special treatment because they can have such a big effect on the party's rights. So that is why they are the primary form of relief that the courts of appeals have dealt with.
Thank you. Justice Alito? Justice Gorsuch? Justice Kavanaugh? Very good. Justice Jackson. Thank you, counsel.
Thank you.
Rebuttal?
Thank you, Mr. Chief Justice. I'd like to start with your point that once you depart from a bright line rule that a final judgment or a conclusive determination on the merits of at least one claim is what's required, then the rule becomes extremely ambiguous as to what could potentially qualify for prevailing party status. A lot of interlocutory orders can be appealable and can be said in some sense to give some benefit to the plaintiff, and yet those orders do not fall within any typical understanding of the legal term of art prevailing party. I think you can also see the ambiguity looking at what is going on now in the circuits. As Justice Kavanaugh put it, the circuits really are at sea on this question, and the sheer number of published Court of Appeals cases grappling with these scenarios shows that the tests the circuits have adopted are not readily administrable. They're fact-intensive and unpredictable, and they're frequently sparking a second major litigation over the availability of fees, which in and of itself is highly judicially inefficient. Second, I'd like to discuss Justice Kagan's point that a preliminary injunction is really a way station and not the final destination, not what a party is seeking in bringing suit, and they often occur in a very compressed time frame without full development of the record or the legal arguments, such that the final judgment might be different. Of course, the final judgment might not be different, but when that final judgment is never reached, there's no way to tell what the court ultimately would have held on the merits of the claim. And third, I'd just like to agree with Justice Gorsuch's point that the combination of the principles that this court set forth in Soule and Buchanan really do answer this case. Soule provides that the court must look to the end of the case to determine the prevailing party, and Buchanan provides that a non-judicial alteration, such as a government's decision to change the law, does not make a party the prevailing party. And under those principles, the plaintiffs are not the prevailing party here. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.